Assembly. You may recall that I discussed the various research projects that were conducted by, related to the bar exam that were conducted by the State Bar. So I discussed, the first one that I talked about was the recent performance changes on the California bar exam. And that was a study that looked at the historical pattern of the pass rate and changes in applicants to find out whether or not there has been a shift in the characteristics of applicants that might contribute to the explanation of why there has been a decline in bar passage rate. So that study was conducted in 2017. We also had, the next study I described was the standard setting study, which looked at the appropriate pass line or the cut score for the general bar exam. And that happened in 2017 as well. And I think everybody is familiar with the study and the outcome of that study. We also simultaneously conducted the content validation study. And that study examined the overlap between what's measured on the exam and what is critical knowledge required for entry-level attorneys. So that study relied on an attorney analysis that was conducted by the National Conference of Bar Examiners in 2008. That was statewide. The last study that I want to talk about that was released this past year in December of 2018 was a study that looked at the California bar performance combined with law student credentials in an effort to find more explanatory factors that might be contributing to the decline in bar passage rate. And that study, again, was released in December 2018 and really explained, the study summarized that about 20 to 50% of that decline could be contributed to these characteristics, but there were still outstanding explanatory factors that might speak to the decline in bar passage rate. So in an effort to, all of these studies have raised other questions, and in an effort to appropriately address those, the State Bar is now embarking on a job analysis study that is going to be California-based. The National Conference of Bar Examiners also conducting a job analysis simultaneously. We're in coordination to ensure that we don't oversaturate attorneys in California and that we gather the information that we need. So the significance of this study is that it's going to help us synthesize the body of knowledge that we know on attorney practice and build on what's been collected with these other studies. So today, you're going to hear from the deans who have been participating in CAPA through this working group. And they're going to explain what this research body attempts to address. And for many of you, the questions that have come up are possibly what's going to happen with the cut score, how can the State Bar modify or the exam to better reflect what newly admitted attorneys need to know, and what can we change about the bar exam to ensure that it's testing what it should. And so this is a study that attempts to do that. But as you'll see throughout the process, that it will take some time and it's going to take some resources. And we've already embarked on that. So as I mentioned, I don't want to keep you from hearing from Dean Jackie Gardina, and we also have Dean Ferrulo on the phone, to hear about their participation in this project. It's right here. And about this important piece of research. So thank you.
So thank you, everyone. And Dean Ferrulo is on the phone as well, and so I'll invite him to comment as I move through. But I thought what I would do at this time to set the stage for a discussion or comment or feedback is to just say what it is we're trying to do, how we're doing it, and then what the timeline is for completion. So Amy already set out what the California Practice Analysis Study is set up to do. And as you can see, it's funded by a grant from Access Lex Institute. And it's going to collect data on what knowledge and skills new attorneys need when entering California practice. So job analysis studies are best practices anytime there's a licensure exam. But California, and I don't think any state, has actually performed a state-specific job analysis as it relates to bar exams. So California will be the first state to do so. The NCBE did it in 2012, and if you remember, we then received a changed MBE exam in 2015 with the addition of civil procedure. Based on that job analysis study that they did. So this is the first time that California has done one. And so the intent is to establish the knowledge and skills a new attorney needs when entering California practice. So what this study can help do is it informs changes to the exam. So we might learn something that changes the content of the exam. We might learn something that changes the format of the exam. We might learn something that changes how the exam is weighted. It can also inform law school curriculum in terms of what we now know about what our graduates need to know and be able to do when they first enter California practice. But what it won't tell us is what's the appropriate cut score. There's going to be no quick resolution to this question through this particular working group or this particular process. It's also not going to tell us how to best test certain skills. So even if the job analysis comes up with a particular skill set that is necessary for new attorneys in California, it's not going to tell us how to test that. So it's going to give us some really important and helpful information, but it's not going to solve some of the bigger questions about the cut score that are percolating in California. And so, Stephen, I don't know if you want to add anything to the what it is we're doing.
No, I think that's good so far. I'll keep going.
Okay. And so CAPA is a working group that's made up of practicing attorneys across a wide range of practice areas, as well as time and experience in practice. And it also has law school deans. Both Stephen Farello and I are on the working group, as well as an associate dean from UCLA. And so what we're doing is helping build the performance domains and build the content domains. And I'm going to show you what some of those are. So, well, that's the timeline. So phase one was really building out these performance domains and content domains. So the performance domains, as you can see, we had set up what are kind of the major areas where attorneys need to act. What skills do they need? This was done originally with the working group, and then there was an expert panel of attorneys that came in for a long weekend and actually followed up and built on the work that the working group did. There's also content domains. So this was a list that originally started with the working group, and then the expert panel of attorneys came in and massaged it a little bit. For example, environmental and land use was added once the expert panel attorney came in as an area or content that many attorneys use in the state of California. So phase one was really building the performance and the content domains. And then the next phase is really going to be the how. How are we going to collect this data? And there's 3 different surveys that are going to be available for California attorneys to participate in. One is what's called the traditional survey. And it's going to ask attorneys to look at both the performance domains and the content domains. And they're going to ask questions about the frequency of that skill or the frequency of knowledge around that content, the criticality of it to their practice. And criticality is defined in part by harm. And then expectation. Was this something that you're expected to perform in the first 3 months of practice, the first year of practice, the first 3 years, et cetera? So we get a sense of the knowledge and skills that are aimed at new attorneys. So that's a traditional survey. The next survey is called the experience sampling method, which is going to be an additional way to check our traditional survey. And that's actually going to ask attorneys to, over a 2-week period, they're going to get a ping. And they're going to be asked what they were doing during a particular time period. So it's an additional check against the traditional survey in terms of what's happening. The NCBE is also doing a job survey at the same time. So a third survey that's going to be in the mix is some of the attorneys in California will also be assigned to the NCBE survey as well. All of the responses to the traditional survey and the sampling method survey are going to be then checked with a focus group to see whether or not it seems to reflect the realities of practice. When is this going to all start to take place? Well, the beta test is going to be in June, with the hope that we're going to be able to deploy the surveys in August and September, with the final completion of the study in December. So, Stephen, is there anything that you want to add to anything that I've said?
Yeah, I might just elaborate on a couple of things if that's okay. I think people know that, like many other people in the room, that I've been largely focused and particularly concerned about the issue of the cut score. I think, as Jackie stated very well, this isn't going to address the issue of the cut score. That is a policy issue, which in my view needs to be resolved. This really is looking at what a future bar exam ought to look like for legal practice in the 21st century. I've been actively involved in this study because I think it's important to getting us collectively in the state to address issues around the bar exam. We're working under the mandate of the Supreme Court, which has made it clear to the state bar and others that the court wants, basically studies that identify and explore all the issues affecting California bar exam and pass rates. And that's why we've had things like the performance study and the CAPA study. So I think we have no choice but to move forward with studies like this. I remain very, very concerned about timing. I think that the State Bar has done a great job, Ron and others, in moving this study forward. And I think the timetable which you have on one of the slides that shows this study being completed by the end of 2019 is realistic. I didn't think that a few months ago, but I think the work with the committees has been pretty expeditious. But I think the notion that this is going to contribute, to a change in the bar exam anytime soon is not realistic. I think it's a valuable study, but we are probably minimum of 5 to 7 years away from, I think, what a new bar exam might be if it were to move in that direction, and we were to put all these studies together and go through the various stages that it would take to do that, analysis, design, testing, and then approval in 2 years. So I think this is, 2 years that it would take to, if you had a new test before you'd introduce it. So we have to think, well, all of this might lead to a great new bar exam 5 to 7 years out. And my view is that we have the more critical issue of doing something about the cut score on an interim basis. So I continue to believe that, and I want to tell you, I think that's something that continues to cause me some concern. But I think that doesn't lessen my view that this is an important study. I want to make two other points. You've seen the slides about the performance domains and the content domains. I think in terms of these as performance domains equals skills and content domains equals knowledge, okay? And a little bit about the process of getting there. Interestingly, both the working group and the panels pretty quickly came to these 4 categories of skills, general skills, that if you have the slide there in front of you, you'll see that they're sort of chronological in terms of, starting with the establishing and maintaining client relationships, then all the way through resolution, whether it be completion of a transaction or conclusion of a case or an arbitration. And that part, in terms of agreement about skills, came pretty quickly, and both groups it sort of worked. More complicated has been the content domains of the knowledge. The working group started with the subjects that were currently tested on the bar exam and took 1 or 2 out and added 1 or 2. And the panel came up with a rather different list. That's where you see the list of 18 performance areas. And around those. They may seem a little bit odd, but the idea is these are knowledge areas. These are not practice areas. There's a broad and a lot of discussion was about the relationship of those two. And I just, it's worth highlighting that in case people have some questions. But that was a sort of an iterative process. I see three things of value coming out of this study, and the first has to do with a lot of the discussions. Both of the panel of the working group are, should we be testing skills or should we be testing knowledge? Okay, and I think that this study is going to help us address that question, because many of us believe that the bar exam should be more a test of skills than of areas of knowledge, and that's not what we're doing a very good job at. And I think that the way this survey is going to be designed is going to get at that issue of asking attorneys both about the skills that they need and the areas of knowledge they need. So the relationship between skills and knowledge, I think that's going to give us some valuable insights into that issue. Then, that being said, I think the study is going to give us some valuable insights into are there some core areas of knowledge or core subjects that should generally be tested. And I think many of us think that is a smaller number of subjects that are currently tested. There's some core of knowledge that lawyers probably ought to have, but let's see what we can determine about what that ought to be, given the variability of what lawyers do in California. And third, I think another thing that I think might come out of this is give us some insights then, if we think about, are we testing more for skills or more for content? What's the relationship of what the form or forms of testing should be, okay? Right now we have an exam which is multiple choice, a reduced performance test section, and, in 1 hour crossover type essay questions. Is that the right way to test? Are there other ways of testing? And particularly if we want to test skills, what is the best way of testing those skills? So I think that this study is really intended to give some insight that will address those three areas. So I hope that's helpful.
Thanks, Stephen. So I think the idea is to open it up for any questions or comments that hopefully we can answer. And if not, I think Ron Pai is on the phone. So if there's more of the kind of analysis piece, psychometrician piece, we have someone here to answer those.
Hi, I'm Holly Fougier. I'm chair of the Council on Access and Fairness of the State Bar. And I wanted to ask whether there'd been thought about including judges. I see it's members of the bar and judges are no longer members of the bar. Judges, general counsel, to get more of an idea from what the expectations are from the people who make the decisions as to what kind of skills they want to see. And it may not be the same exact survey, but just a thought to have that in the mix.
I don't know who's best to answer, if that's Ron or if someone at the State Bar understands kind of the larger sample size or how we would do that, or if we would do that.
I think Ron should know how we're pulling the sample.
Yeah.
Yeah, Ron, is that something you can speak to as to how we're pulling the sample?
Can you repeat the question? I didn't hear it clearly.
Sure. I want to actually get it from Holly.
The question was whether any thought had been given to including judges who are not members of the bar and so probably would not be pulled out of a sampling of bar members and possibly general counsel, some of whom are not admitted in California, to find their perspective on what it is that we look for in terms of being the decision makers or the hirers of lawyers from lawyers at various stages.
Okay, My understanding is correct. I hear parts of it. The question is about what is the sample size you will need in order to get feedback from judges about what the skills and knowledge should be?
Yeah, so Ron, the judge asked whether or not, because judges are not members of the bar and the survey is sampling bar members, is there any thought given to including in the sample judges and perhaps in-house counsel who may not be licensed in California or members of the California bar, but who hire and work with new attorneys?
We can certainly include them as long as we have the distribution list. But the bigger problem is the design of the survey questions is really not intended to get views about what should be covered or what's considered important, because it's really, especially the experience sampling, we're trying to get empirical data. In terms of the judges' feedback, we have 2 judges on the working group, and I think it would be helpful also to have that feedback in the post-survey process, including the focus group.
And those
I'll have to understand a little more about the intent of the specific kind of questions we want answers from judges. General counsel, without being a bar member, I don't know whether we could get that information in terms of a distribution list.
And I think part of the thing, and we talked about this in the working group, is that we want to know what California attorneys are doing or need to know and understand broadly. And then the focus group later will bring in those who kind of supervise new attorneys. So the surveys themselves aren't intended to answer the question, what should new attorneys know and understand? It's intended to learn what California attorneys are doing and what knowledge they're using.
Hi, Martin Pritikin, Dean of Concord Law School at Purdue University Global. 2 questions. One is, I have a couple of potential comments on the content domains, but if that ship has sailed, I don't want to, waste anybody's time.
I think comments are always welcome because the working group has another meeting in June. So
Okay.
I think absolutely providing comments so that if there's anything that was missed or not caught, that we can address.
Okay. So I'll just say quickly, I know that this is supposed to be content and not necessarily practice areas. I was kind of surprised not to see torts on here, not just because it's a foundational first-year subject, but when I was a new lawyer as a business litigator, I used torts all the time, and I had to know about it. The other thing is, as a new lawyer, I actually had to do a lot more bankruptcy law than I expected. Now, I assume that's subsumed administrative law and procedure, but just in terms of survey design, we might want to make sure that we define these terms sufficiently that people might know something that's not on the list, where would it go?
Yeah, and it's a great point. So within each of these content domains are what's called subdomains. Okay. And I know that we had a discussion about bankruptcy in particular because it came up in the working group. So I have a list of all the subdomains in my packet.
Sorry, what was the first one that you said wasn't here?
Torts.
It is here.
Yeah.
Content domain torts.
It's not on the slide.
It's not on the slide.
And number 2, bankruptcy is under finance.
Yeah.
It's a subdomain.
It's a subdomain. On the slide that is up on the piece right now, torts is not on there, Stephen. So I'll double check on my.
No, it's on my version of the slide. Somehow it got cut off. It's alphabetical and it's there. Yes.
Oh, you're right. It comes after tax.
Okay. Great.
It comes up after tax.
Yeah.
Okay,
it's
good.
Alphabetical.
My other question is, and this might be for some state bar reps, but I guess I'm just curious, the fact that we're undertaking a study to try and determine whether any changes should be made to the bar exam, does this presume that the state bar is not considering the possibility of moving to the uniform bar exam? Or if they haven't ruled that out, might this be used to make suggestions to the NCBE itself about changes to the UBE?
What this study means is that everything is on the table. And frankly, the fact that the NCBE is conducting its own job analysis at the same time that California is conducting its job analysis will give us the opportunity to say, are the knowledge and skills that are required of California attorneys different from the knowledge and skills that are required of entry-level attorneys elsewhere? If the answer is no, the knowledge and skills that are required of attorneys in California are the same as they are across the nation, then I would imagine that we would certainly engage in that discussion of, well then, should we be evaluating usage of the UBE here in California and not have our own separate exam since the knowledge and skills needed are similar? So everything is on the table. This really is creating the start to the process to evaluate what the bar exam should look like. If it's going to be the UBE or California specific. If California specific, what is it we're testing? How are we doing it? As Jackie talked about, if we determine that rote memorization is a thing of the past, nobody needs it, nobody needs to know any of the specific content domains, they need to know how to analyze, how to write, how to engage with clients, then we need to figure out how to test that. And so we would follow up the job analysis with a content validation study to say, here's what the job analysis said that that entry-level attorneys need to know and be able to do. Does the current structure of the bar exam test that, yes or no? If no, then what is the appropriate form and content and of the bar exam that would in fact test to those skills and abilities and those knowledge domains that are necessary? So that was a great question, Dean.
And we probably have time for a couple of questions, and I see one right here from Chapman.
Yes, hi. Mario Monero from Chapman. The content domains and even the subdomains are general categories. But the issue isn't always the categories, but the execution of those categories. So, for example, you alluded to the fact that the NCBE study resulted in the addition of federal civil procedure to the MBE. The issue isn't whether you add federal civil procedure, but what do you ask? And that can often be the really difficult thing, because as I've noticed over the years, more and more less tested things seem to find their way on both the essay and the MBE. And that is something I'm not sure is really taken into account here. For example, in February, I get testing the new rules of professional conduct. I'm not sure I get testing a brand new rule in California that has no ADA equivalent in terms of employment of disbarred attorneys, for example. So my point is, what, if anything, can you do to address the specifics and the execution of this beyond just some sort of general agreement on content, domains, and subdomains?
I don't have a response to that, so I don't know if that was just a comment, it wasn't a question, right? Well, I mean, the working group itself isn't involved in creating the bar exam questions. So I wouldn't be something that the working group would be able to respond to.
Ira Spiro, Dean of People's College of Law. Two subjects that might be buried in subheadings there, but immigration and constitutional law, are they in there in subheadings?
Yeah, I'll have to look. I know we had a long conversation about immigration, and I can't remember where we fell on it, so I'm going to have to look in the subdomains. Stephen, I don't know if you remember.
Administrative law.
Right. Yep.
And constitutional law, I suppose, is under legislation, is it?
Yeah.
Con law is under administrative? Well, anyway, as long as it's there, okay.
Content domain number 4, which is missing from up there, is constitutional law.
Oh.
So
okay.
There's 2 missing up there because Stephen said 18 and there's only 16 up there. Constitutional law being one of them and torts being the other one.
Okay.
So you guys are good. It was missing for a reason, and well done. So.
Okay, never mind.
Yeah.
Was there another question in the back?
Good morning, everybody. I have a fundamental question, it's sort of the cart before the horse. I mean, when you get to content, if there's an effort ongoing to completely revise, perhaps, the California bar exam, to do what it should be doing, which is testing minimum competence. 40 years ago when I was in law school, I thought it was a fallacy, that I had to study trust in the states and community property. Practicing for 30 years, I can assure you I never spent probably 60 seconds thinking about any of those issues and other subjects that I was required to study and be tested at an issue. I referred to a partner, I referred to a colleague. My question then relates to if to be as effective a test for minimum competence and for people who are in law school who have some idea of where they're going to practice, whether it's public sector, private sector, what areas of law. I believe deeply, in having taught law, practiced law, that giving people the opportunity and schools the opportunity to educate and test individuals, students, so that they become better competent in the area of law they're most likely going to practice it. Because the idea that they're minimally competent in 13 subjects, I think is fallacious, and I think it's something that has been bedrock philosophy of the bar for as long as I guess they've given the bar. Although I do remember probably 45 years ago, there were people could select questions they would answer on the bar based on subject matter. So getting to the current study, if you're trying to determine minimum competence for the practice of law, is there any thought or consideration in seeing how law has become highly specialized and how that would then reflect on testing minimum competence in various specialties and then getting the content of the bar better aligned with that, which will allow students in law schools to better focus on where people really will end up becoming competent ethical practitioners.
Yeah, and Stephen, I don't think you could probably hear George's.
I couldn't hear the question.
Yeah, well, it's actually something that you've spoken to, which is the idea that law students more and more, or at least when you enter practice, you are specializing, and has the study doesn't. The study could give us information certainly about that kind of thinking, but I think what Donna said is everything's on the table when it comes to potentially redesigning the bar exam. But Stephen, George's question or comment was, has there been any thought given to the idea of focusing the bar exam on specialties in some way? And George, I hope I captured that correctly.
Narrowing the focus.
Narrowing the focus, yeah.
Yeah, I mean, I think that's what I hope will happen. Because I hope what will happen, I think what this study is going to show, okay, is that it's going to get rid of certain myths. First of all, it seemed to inform the bar exam. First of all, that a large number of people are starting off in California as sole practitioners doing everything that comes in the door. And we now know that that's about 2 to 3% of the people coming out of law school who do that. Number two, a second myth is the vast majority of lawyers in California are litigators. And that's just false. What we have in California is a widely varied, highly specialized, highly competent legal force. They're doing all kinds of things. And the way the study is going to work, at least the key part of the study is, when I get the questionnaire, I'm going to identify myself as a business lawyer. And then I'm going to go to those areas of skills and knowledge domains that are relevant to my practice and identify within those areas of my practice the ones that I practiced in certain times of my practice. Those skills and knowledge that I had to have within the first month of my practice, and those that I had to have later. I'm not going to get to the part that talks about evidence, for example, or civil procedure, because they're sort of irrelevant. And so the idea will be is, I think it's going to show I think the number's going to show is that skills are more common among the variety of lawyers in California than many areas areas of knowledge that we currently test on, and that if there's a core of subjects that are more comprehensive among lawyers in California, it's a smaller core than the 14 subjects we're now testing on, because we do have a highly specialized, focused, increasingly specialized and focused legal profession. So I think it's going to give us some indication of that. What the examiners are going to do about that is sort of a separate question, but I hope they'll use that in an informed way and stop designing an exam which is largely focused on the idea that we're preparing lawyers to be general practitioners or litigators.
Are we done?
Does that answer your question?
Yeah, I just wanted to give you an opportunity to follow up, and I think, is there time for one more, Susan? Yeah, Heather.
Susan Prager from Southwestern. I apologize for arriving late. You may have covered this, Jackie, but I'm wondering whether any of the studies is looking at the growth in subject matter content on the MBE.
No, I mean, this is a job analysis study, so it's not focusing on what the NCBE is doing in relation to the subject matter areas that they're testing on. And so we don't have any involvement with that as the working group.
But
Susan, I think that's one of the things the NCB is looking at in its study.
Right, and so there's 3 surveys that are going to be deployed, 2 related to the California job analysis, but the NCBE is doing their own job analysis this year as well. So I'm assuming that's something that they'll be looking at in relation to their own job analysis study. But this working group is focused on the California practice area. And just to kind of close the loop on this, I know as a working group member, one of the questions that comes up again and again is, what sample do we need? Are we going to get enough responses? Are we going to get enough responses in particular areas? For example, we certainly want a number of new attorneys to respond to the survey. We want to make sure that the survey has enough respondents across practice areas, et cetera. So I know that when this is finally available, I'm definitely going to be using my alumni email listserv to send out reminders to our alums to please participate in this particular study, because it's going to be really critical and important to the development of what I hope is going to be a better licensure exam in the state of California. So I hope that you guys will do the same with your alums, especially those who might be new to the profession, because their feedback about the knowledge and skills they're using in those first 3 years is going to be really critical for us understanding what it is a new attorney needs.
Thank you, Jack.
Yeah. Thank you, Stephen.
Thank you, everybody.
Thank you, Stephen and Ron.
Bye.
Okay, so at this point, so CAPA is a long-range study that could result in long-range changes to the bar exam, but now I'd like to turn to something more immediate, which is our Bar Strategies and Stories initiative, which you may have first heard of as the Productive Mindset Intervention Program. We've brought Dr. Victor Quintanilla and Dr. Mary Murphy here from the University of Indiana at Bloomington. They are 2 of a number of the study designers of this initiative. We've run this program once. We're doing it again in conjunction with this bar exam, and there is still time for your students to participate, and we hope that you will be excited to help us spread the word and have them register before June 3rd. So we'll need just a minute to open up their presentation, and then we'll go ahead and get started. And are there folks who know whether Bar Strategies and Stories is something that their students have used so far? We did a small pilot last summer, and we're hoping to greatly expand it this time. Ira, I see. Yeah. Good, very good. And students will have until June 3rd to go ahead and apply right now. One of the challenges that we've had in applying for this is that the students must apply themselves through our IMS computer system. So it's not a system where it's a link that we can forward in order to keep the integrity of the study design. And that means we need to get them into the system, or we need to send them email. And one piece of feedback we've gotten is that students haven't read email in quite some time. So part of what we'll be asking you during the question period is to think about what are the best ways that we can remind students, and are there ways that you can help? But before that, let's learn a little bit more about what the program is, and I'm going to turn it over to the team.
Thank you so much. We're so grateful to have this opportunity to speak about the California Bar Strategies and Stories program, a psychological intervention that we've designed to promote. Can you hear me? Let's put it a little closer.
There's a main button right.
Is that?
It's blinking.
Can you hear me?
No, he's bringing one that works.
Okay.
Do you want to use this one?
Can you hear me now? Terrific. Perfect. All right. Well, thank you so much. And again, we're really grateful to have this opportunity to speak with you today about the California Bar Strategies and Stories program, a psychological intervention that we've designed to help improve bar passage. So to begin, my name is Victor Quintanilla. I'm a professor at Indiana University, the Maurer School of Law, and the co-director of the Center for Law, Society, and Culture.
My name is Mary Murphy. I'm a professor of psychology and cognitive sciences in Bloomington at Indiana University.
And I'm Sam Merman. I'm a professor at the USC Gould School of Law.
Our team is composed of researchers at a number of universities, Stanford, USC, UCLA, IU, and Wake Forest, and we're in law schools, sociology departments, and psychology departments. What we're going to be speaking about today, here's the brief outline. In case you missed it in April 2017, we'll be talking about some of the psychological friction that law students experience both in law school and also when preparing for the bar exam. And this is the friction that our program was designed to address. We're also going to be speaking about surveys and focus groups that we conducted in the LA area in 2017 with California bar exam takers. And we'll talk about the design and the evaluation of the psychological intervention that we created, the California Bar Strategies and Stories program. And we'll end with some of the additional predictors of bar passage that we found when doing our study.
All right, so I'm going to cover a little bit about the psychological friction and what psychological friction even is, because you'll see how this was adapted in the design and evaluation of our intervention. So what we know from research is that students experience significant psychological friction both in the law school experience and in their journey to taking the bar exam. Now, the way that psychological friction can show up is in several different paths. So feeling that one doesn't belong, either academically, culturally, or socially, experiencing doubts about one's potential, having maladaptive theories of stress, which we will get into in a moment, and endorsing fixed mindset beliefs about one's ability, that you either have it or you don't, and there's not much you can do to change one's level of ability, versus having a growth mindset of ability, which is the idea that I can learn, expand, and develop my ability and talent over time through approaching the right strategies, seeking help, and persisting. So what we did for the initial surveys and focus groups, we partnered with the State Bar of California in 2017, and we initially gathered data regarding students' experiences of psychological friction when preparing for the bar exam. And this was supposed to be used to design and evaluate an intervention with the 2018 cohort who would sit for the bar exam in July 2018. And that intervention was aimed to alleviate friction, psychological friction, tamping down stress, and freeing up executive resources in order to perform at one's potential. So what we did was that in June 2017, we designed a survey and we sent it to recent law school graduates as they're preparing to sit for the bar in July 2017. So this is in the moment of them studying and preparing. And we surveyed them about their experience to understand test takers, first, their mindset beliefs about bar exam performance and these other areas of psychological friction, whether they were engaged in adaptive or maladaptive study behaviors, and how they felt around self-efficacy and competence to pass the bar. One of the most overwhelming findings that we discovered in those surveys was the best predictor of positive outcomes for students in that cohort as they were studying was having a growth mindset belief about the bar exam. Now this is sort of a little bit whited out here. It's hard to read, but an example item of this is agreeing with the item, your test-taking ability is something that you can change substantially. So it's this belief that you can actually develop and expand your ability to take these high-stakes tests. Now, growth mindset beliefs about the bar exam was related positively to all the psychological experiences you'd want students to have as they're preparing for the bar exam. So for example, greater beliefs that they have potential to succeed on the bar, capable of meeting the demands of the bar, capable of handling the stress while they are studying, and engaging in positive emotion regulation techniques that we know to be useful to engage in encoding and retrieval of information. We also found that endorsing these growth mindset beliefs about the bar exam also resulted in lower negative outcomes. So this is also a positive thing. Lower levels of pluralistic ignorance, thinking I'm the only one struggling in this moment as I'm studying. Lower levels of stress, lower scores on a depression inventory, and lower scores on loneliness surveys. We also found that these growth mindset beliefs result in greater self-efficacy and confidence about passing the bar. And in case you think these growth mindset beliefs are just sort of rainbows and sunshine and cause people to take their foot off of the gas as they are studying in this moment before the exam, we actually find that it didn't change their studying behavior in terms of the time spent studying for the bar. Both fixed and growth mindseted students reported equal amounts of time studying. It's just that students had these other positive psychological benefits while studying when they endorsed the growth mindset belief. It also didn't change students' importance of doing well on the bar or how demanding they thought the bar was. So it didn't sort of create this rose-colored glasses. Instead, it just sort of gave them the psychological tools to be able to engage productively in their studying while they were sitting for the bar. We conducted then focus groups, building off of what we learned in those surveys in December of 2017. And the results of those focus groups were threefold. We found 3 areas that just kept coming up over and over again in these focus groups. These focus groups were actually conducted in the LA area among many schools here in the area. And those students reported 3 areas of psychological friction. First, many endorsed these limiting mindset beliefs and had maladaptive behavior that resulted from those mindsets. I'm going to cover each one of these in a little more detail. Stress also was another area of psychological friction, and the stress came from a lot of things, of course, fear of failure, time constraints, amount of information, and negative feedback when they were studying as they took the practice exams and were disappointed with their scores. But we also started to hear this sort of recursive negative process of students actually stressing about the stress. I started to notice that my heart rate was being raised every time I sat down to study. My palms were sweaty. I couldn't actually concentrate. I found myself having to reread everything that I was reading. So stressing about that stress was actually undermining the efficacy of their studying behavior. And finally, the third area of psychological friction was flagging motivation, particularly in the weeks leading up to the bar exam, where they'd been studying intensely for quite some time, and then they found it difficult to continue at that level of intensity the entire summer until they took the test. So what are these areas? And the reason we're going over this is because we incorporated each one of these 3 friction areas into the intervention itself. So as I mentioned before, these fixed mindset beliefs are beliefs about the malleability of human characteristics like intelligence and ability. If you endorse the idea that intelligence and abilities are fixed, you endorse the fixed mindset. It means you think potential can't be changed, you either have it or you don't. Whereas those who endorse growth mindset beliefs think that these abilities are malleable and can be improved with effort and learning. Why are these things important for the bar exam? Well, because we know that fixed mindset beliefs undermine both motivation and performance, particularly on high stakes tests. when one sees mistakes as a sign that they've reached the end or the limit of their ability, this causes students to actually move away from those areas of studying and focus on the things that quote unquote come easily. Whereas growth mindset beliefs boost motivation and performance, and this is especially effective on high stakes exams, right? So when growth mindset beliefs are salient for students, they show greater effort, persistence, and good strategies while studying. The second area of psychological friction were these mindset beliefs about stress. So some students held the belief that stress is debilitating and something to be avoided. This is really a problem when you need to be studying for a high-stakes exam and experiencing a lot of stress while doing so. There were other students who held an adaptive belief about stress, which is that stress is actually necessary and facilitating to performance, meaning that stress is actually useful to improve motivation, learning, and performance. And we know that this is useful for students when stress is high, as in high-stakes testing environments. So one of the things we used in the intervention was really teaching students about the science of stress. For example, this is the Yerkes-Dodson curve, right, where we know that actually with a little bit more stress, this increases attention and executive resources and focus, and that stress is actually required, at least a certain level of stress, for optimal performance and encoding and retrieval of information. The last area of psychological friction was that flagging motivation that I talked about a moment ago. What we did here was we actually used research in the social psychological area around one's sense of purpose and how reminding oneself of one's sense of purpose re-engages motivation and enhances attention. In this little graph here to the right, which is hard to see here, we see that the more that students sort of reminded themselves about their purpose for learning, the greater they were in persisting on difficult tasks like studying. So what we know from this set of research is that maladaptive mindsets around mistakes, fixed mindset beliefs around mistakes, bad theories of stress, as well as not reminding oneself of one's purpose, creates greater activation in the amygdala. And there's neuroscience studies to support each one of these points of psychological friction. This means that students are really focused on their emotional response in this moment of studying, which hampers the ventral medial prefrontal cortex, which is really what needs to be activated to encode and retrieve information. It's sort of our thinking brain, right? Our mentalizing part of the brain. And so we know from research that productive mindset interventions that sort of focus more on the growth mindset, adaptive theories of stress, and reminding oneself of one purpose is going to reduce activation in the amygdala and increase a blood flow and activation to the prefrontal cortex. So that is sort of the science that we harness to create the intervention. So our theory of change really is as follows. Students come into this at the end of their spring semester in terms of registering for the bar exam. They're very aware of the high stakes nature of the exam. And what we thought was that approaching those early exams that they have to take, the practice exams, from a fixed mindset view would make them very stressed about the mistakes they were making, causing them to avoid the areas that they actually should be spending more time focused on rather than less. Students would stress about the stress from this, and that would result in flagging motivation to persist. So Victor's going to tell us a little bit about what we did to address these psychological frictions.
All right, so let's turn to designing and then evaluating the program. Let's turn to designing and evaluating the program. So first, I wanted to say we want to express our gratitude to our partners, the State Bar of California, in particular Leah and Ron P. as well, for all the help with the statistical matters, and also Amy Nunez as well. We wanted to thank our funders, Access Lex Institute, for the funding that allowed for this project, and also the Law School Survey of Student Engagement for some of the data that went behind initial studies for this research line. All right, so the idea with the intervention is, what if we could interrupt these maladaptive loops during the bar exam process? So what we did is our intervention had an initial survey in March, which allowed for an opt-in. This was when students were enrolling in the bar. And then during the summer, We sought to interrupt these processes with the program itself, and the program was disseminated in May. So if we could cut off these kinds of vicious cycles, these loops, during the summer, we may be able to improve bar performance and the bar experience as well. So let's talk about the program itself. This was designed for U.S. law school graduates preparing for the California bar exam, and it was provided such that applicants could opt in March during 2018 when actually enrolling in the bar exam. All applicants who participated consented, and there was an IRB protocol that was approved. We also collected demographic characteristics. These were quite important for us because they allowed us to engage in stratified random sampling, random assignment. So in effect, we could randomly assign in the treatment and control, and we could ensure that there was balance between the treatment and control conditions. We also designed this to be fairly brief, actually, in March. It's a 45-minute program that they participated in May. And it was a randomized control trial, which allowed us to evaluate the causal effects of the program. And the primary metric for evaluating the program was bar performance. And that was what we did in July 2018. So just to be clear, this program didn't change the test or the administration in any way. This was basically a supplement for the bar prep process over the summer. And again, it's a brief program that was delivered online in May for the students who opted into it when enrolling in the bar exam. So now I'll turn it over to Mary.
Okay, so as Victor said, the study design took a randomized control trial format, and RCTs are really the gold standard used to examine efficacy and the causal impact of a treatment. So every test taker was, after they consented to be part of the program, they were randomly assigned to one of two conditions. If you were randomly assigned to the control condition, you learned of study strategies and tips that have been shown and proven to be effective when studying for the test. Things like be sure to outline immediately following the lecture. Be sure to review your outlines and notes every week. The treatment condition included some stories and strategies around handling those moments of psychological friction. We called it the productive mindset intervention, and we also included the study strategies as well. So the control and treatment are both active in some ways. They get study strategies and tips, but only the treatment condition also gets that handy psychological intervention around how to handle moments of psychological friction. So to depict this, if you have a study population here, let's say we have men and women in blue and green, what we did with the stratified random assignment was to be sure that equal numbers of men and women, and we did this with race, first generation status, any other characteristics? I think that was mostly it, for race, first generation status, and gender. And LSAT as well, so that LSAT would not be confounded in the population. So we had half of individuals from these groups assigned to the treatment, half to the control. Then in May, they received the actual intervention online, and then after we had the results in December, we were able to compare the results. So the treatment really focused on three main messages. First, mistakes are common and will help you identify where more, not less, effort is needed. Second, stress is useful and not debilitating to reach peak performance. And third, reminding oneself about one's purpose for taking the bar helps overcome flagging motivation. So if you were assigned to the treatment condition, students saw a summary of those surveys we had conducted with prior bar test takers on these 3 points and how important they were. And then students read and also heard the stories of students being read out loud to them that really talked about these 3 different areas. So let me give you an example of what this looked like. I'm just going to give you 2 examples. Here's the first example in the treatment condition. So a student would come here and they'd hear this story. I'd done pretty well in law school, so I was shocked when I got my first practice test results. I mean, I wasn't expecting a perfect score, but I didn't expect to do that badly. I started to worry I'd never be able to pass. From then on, each mistake felt like a sign that I wasn't cut out for this. So I avoided those areas instead of learning from the things that I was getting wrong. Then one day over lunch, a friend who sat for the bar last year asked several of us if we'd recovered from our first practice exam yet. We looked around, and it became clear from our faces that none of us had done well. But we had each kept it to ourselves because we didn't want to look bad. Our friend smiled and shook his head. Of course your first practice test sucked. Everyone struggles at first. That's why you're taking a class and studying. Then he said, let your mistakes show you where you need to go deeper with the material. That really resonated with me, and from then on out, I really tried to embrace the idea that success is about learning from mistakes. Over time, I found myself learning more, doing better, and making progress. In fact, some of the subjects that I did the worst on early in the summer, like property, became some of my better ones by the end. So you can see how this message around stress and mistakes actually being useful for guiding attention is really coming out in this quote. A second story on really the theories of stress is as follows. When I first started studying for the bar, I stressed a lot about everything I had to learn. Then I started stressing about being stressed, and that made it even harder to focus. I was talking to my sister about it, and she shared this amazing book called The Upside of Stress, which taught me about the science of stress. It shows how stress, the right kind, in the right amounts, could really boost your performance. Stress is just your body's way of rising to meet a challenge, to help you accomplish something you care about. So I tried to find ways to use my stress so it would help me study for the bar. Like when I sat down to do practice essays, I reminded myself that the excitement I felt was my body's way of keeping me focused on the important stuff and reaching my goals for the day. Don't get me wrong, I was still stressed, but now instead of stressing me out more, the stress helped me stay motivated and energized and got me in the zone. After students heard these stories, they then engaged in a practice called Saying is Believing, where they wrote essays about how these processes were true for them and could help future test takers. This is really important psychologically. It's sort of seen as critical in these types of interventions because it puts applicants in the role of benefactors and not beneficiaries of some kind of program, reducing the stigma around participating in a program like this. It helps students connect the intervention to their own experience and lets them advocate for the message to an important external audience, here future test takers. So Victor's going to tell us a little bit about what we found.
All right, so now we're going to turn to evaluating the program. So again, this is for those who participated in the program for the July 2018 bar exam. So first we're going to talk about what's called an intent to treat effect. This is the most, what we would say is the most conservative way of evaluating the efficacy of a program. And what I mean by this is this includes everyone who opted into the program and received the program, and who opted in the program in May, whether or not they actually clicked on the link to take part in the program. So this was initial test takers, repeat takers, students in foreign law schools, essentially everyone who was randomized into a treatment and control, regardless of whether they actually finished the program or even began the program. So this is the intent to treat. What we see is that in the study skills condition, 48% of participants passed. I should also say one thing, this is controlling for LSAT as well. And so what we're really doing here is we're controlling for LSAT to examine the effect of the program above and beyond prior performance. And so what we see is 48% pass in the control condition, and in the treatment condition, 55.5% of participants passed. So what we see here is that using this a conservative measure of the program increased the bar passage rate by 7.4%. Using these strategies seem to have been effective. We can also examine this using an average treatment effect approach. What this does is it says, let's examine the effect for those whom the program was designed for. So US law students in US law schools taking the exam for the first time who received the program in May, and then actually completed the program. That means that they saw and went through all the quotes and then wrote the letter to the future test taker. What we see here is that in the study skills condition, we saw a similar pass rate, close to a 49% pass rate. But in the productive mindset treatment condition, it was a pass rate of 68%. So this is increasing the pass rate by 18.2%. Now we have a star here because this was a much smaller sample size. When comparing the intent to treat with the average treatment effect, the intent to treat included 1,638 test takers, whereas the average treatment effect looked at 188. We'll mention this, by the way. This is one of the reasons why we want to seek to increase the number of students participating in the program, given what we've seen with these effects. This leads us to believe that the effect size is somewhere between the 7.4 and 18%. We're still ascertaining the exact effect size of the program. We're going to need replication to increase the confidence in the effect. And this will allow us more precision and understanding. But that being said, it does seem that the program and these strategies were helpful to the students preparing for the bar exam. A couple of things as well. Part of the process involved collecting some initial measures in that opt-in March survey, which we then were able to link back and look at bar passage relating to. Some of these things may already be familiar to many of you in the room, including that LSAT, when you have the full range of LSAT, is predictive of bar passage, as is final law school GPA grades. You can see that as well. We saw as well that repeating the bar exam actually, it makes it less likely. You're less likely to pass the bar exam if you're taking it as a repeater. So we saw that negative correlation there. And then we saw some things relating to some of the headwind that people experience over the summer, like being fully employed or part-time over the summer. That's negatively correlated with bar passage. Also, caring for dependents, whether that's your own children or a parent, is negatively correlated with bar passage over the summer. We also saw first-generation college students. That was a risk factor that was negatively correlated. Lower socioeconomic status. A subjective reporting of socioeconomic status was negatively correlated with bar passage. And then we saw racial group differences with white participants being more likely to pass the bar exam and black participants being less likely to pass the bar exam. That said, we also saw this psychological aspect, which was stereotype threat, meaning the more likely it was that an applicant would ruminate over the summer whether others believed that them or people like them had what it takes to pass the bar exam. That was negatively correlated with bar passage. And you can see that that kind of rumination is related to some of the racial differences, SES, first-gen status, and perhaps some of the other risk factors as well. We also saw that there were a number of psychological predictors over the summer. So students who experience more anxiety preparing for the exam, actually, that there was that was negatively rated with bar passage. Also, people's confidence in their own abilities to prepare for the bar exam was positively correlated in their belief of whether they could actually pass the exam. Challenge versus threat was related as well. This is, you can ask people how difficult it is to prepare for the bar exam and about their own ability to prepare for the bar exam. The more that people were in a threat state there, that is, the less likely that they thought that they had the capabilities to study for the bar exam, the less likely they were to do well. One thing we wanted to point out here is, so there's a question of what can we do within law schools about some of these experiences during the bar exam prep process. And we do have some predictors of experiences within law school that we were able to correlate with these experiences. And one of the most important one of these predictors was belonging in law school, right? So students' sense of belonging in law school measured in terms of what they felt like they belonged in law school, or what's known as belonging uncertainty. The more often they ruminate about whether they belong in law school, this was highly predictive of anxiety, of a lack of what's that? When studying for the bar exam, was highly predictive of anxiety when studying for the bar exam, flagging confidence in their abilities to prepare for the bar exam, and a decreased beliefs in their own capability and capacity to meet the demands of studying for the bar exam. We then found, like I've already said, that this is anxiety, flagging confidence, flagging beliefs were also predictive of bar passage. And so this suggests that there are things that we can do within law schools that will have kind of a cascade into the bar exam study process, which can affect bar passage as well. In terms of current and future directions, right now we're replicating the program, giving the promising results that we saw in July 2018 with 2019 bar test takers. Registration is still open for the program. So when your students are enrolling for the bar exam, the module is still available. They can sign up for this, and they'll also receive emails from time to time if they have, from the State Bar of California, if they have already applied for the bar exam, that this program is available to them. We're working to increase the sample size. There are prior studies that suggest that these kinds of interventions can be most effective for students that are at a disadvantage or facing particular headwind. And so we're increasing the sample size so we can really investigate whether that's the case here. Our initial results were that the program seems to have been helpful across the board to those within the treatment. And we're developing similar programs for repeat test takers, a separate module for repeat takers. And with the encouragement of Access Lex and some of our partners, they've encouraged us to begin thinking about making the program available to some of the UBE jurisdictions as well. Given the results that we see here, the theory would be that it would be effective for students in some of the UBE jurisdictions as well. And in the future, our team, Sam, Mary, and I, and some of our others, would be interested in developing psychological interventions earlier in the law school process as well, around sense of belonging. So with that, one of the, I think, the key takeaway points here is that these meetings that students make during the bar exam process around growth mindsets, around the mistakes that they make and whether there's something to be threatened by or to learn from, what stress means during this process, their sense of purpose and also their belonging in law school can shape the motivation and performance that they have on the bar exam. So thank you.
And we're going to be able to take some questions. I bet there'll be a few.
Okay.
Hello.
Just a real quick question. If they sign up, are they going to automatically be in the treatment group, or are you still dividing people into a control group?
Right. We are fully replicating this design. So given the effect size uncertainty, we still need to replicate with treatment and control. So they will have a 50-50 chance of being in treatment or control. We saw that the control actually provides a little bit of a boost too. So I think either one of the treatment or control, obviously we have a theory around and we're seeing better results for the treatment compared to control, but both should be useful for students who are sitting for the bar.
One thing to say on that is that in a future year, once we've replicated and truly seen year over year that the program is effective for students, this is something that we would like to make available for all takers.
In the treatment, just the treatment.
Yeah.
Yep. We can hear you. I don't know if everyone can. We can hear you.
Okay. I had a question. When you were, taking data on the students and what they're doing during the summer, did you also take into consideration the type of programs they were doing, whether or not they had tutors or whether or not they had bar programs that provide this kind of support? Because a lot of what you talked about, I do for my students, and I actually provide that same sort of feedback and motivation to students that I tutor. So did you take that into consideration of students who were just doing their bar program, or if they had additional resources available to them as well?
Okay, so we did ask those questions as to what prep methods and tutoring and other kinds of programs that they did, and we had sort of a whole list. People could check them. And we didn't see an effect of that, mostly because there was so many students at ceiling here, and that students were reporting, at least to us, that they were taking part in many of these different things. Almost all students were enrolled in some kind of bar prep program, so there wasn't a lot of variability there in order to predict these outcomes. So, you know, that's kind of what we found. Now, we didn't sort of go deep into, you know, a particular kind of tutoring program or anything like that. We just asked about tutoring, bar prep courses, whether those bar prep courses were in person or online, whether they were using study groups, you know, these sorts of study strategies. And, you know, almost everyone was reporting using multiple of these.
So there's a lot of good information in the slide set, but I'm out of Depo scribbling practice. So will we be able to get a copy of these slides?
We're happy to provide the slides, absolutely. And we'll be, one of our plans is to make the results more widely available in white papers with the State Bar of California as well.
And my second question is, in terms of self-efficacy, one of the things I run into with my students is the Dunning-Kruger effect, right? Was that part of your analysis, or did you ascertain whether the students fall into that category or not?
Yeah. So Dunning-Kruger, for those who don't know, is sort of the belief that everybody is above average. Everyone believes they are above average. But when you ask people how good they are, like 80% say I'm above average, right? When it just can't be statistically true. And so, yeah, so we actually, on self-efficacy, we asked a scale of self-efficacy that actually has been shown to not have those kinds of self-presentational effects that we generally tend to see with that overconfidence bias. So we had some really nice normal distributions of self-efficacy in the data, which allowed us to then use it as a predictor of bar passage. So I think it really depends on how, I also think because we asked these questions early in the process, there was still a lot of uncertainty, and they were, you know, about to go into these bar prep classes. They knew that they were going to be probably not doing well on the initial practice exams. So I think it depends also where in the process you measure self-efficacy, I think, as to whether you get that top out.
I think, and I think I would add just two things to that. And one is, one of the measures that we've included here that was actually quite powerful was that challenge and threat measure that's been validated in much of the literature. And again, that's the idea. If you could ask someone how challenging preparing for the bar is, studying for the bar is, or passing the bar is, and then you could ask them, do they think they have the ability to do so? And you could begin looking at these things together. What we see is, I think many of the students will answer quite honestly if they have, for example, a lot of outside, maybe they're working full-time over the summer, caring for parents or caring for children, or have other demands. They're answering honestly about whether they're less capable to do so. And what we've seen from other literature, challenge and threat is actually quite related to some of the physiological aspects that we've seen. So including the stress response, including all of these things are related to. The second thing I would say is around efficacy. One of the things that's really interesting here is on the Dunning-Kruger point, it seems that students receive so much feedback over the summer on those practice problems, or having the experiences coming out of law school, knowing how they did, that it's hard. It is possible, but it seems less likely. It seems like the vast majority of people who are going to be thinking about their level of confidence or how likely they're going to do it will be based on all of that prior information, and that kind of updating makes their beliefs about their confidence and self-efficacy more accurate or a useful indicator as well, right?
So did you collect information about what else? Did you collect information about what else they were doing to prepare for the bar?
We do have that actually, and this.
What kind of examples?
Yeah, this current round in particular, we'll have more nuanced data collected in the March wave in our second time. So other things that might include, for example, did their law school offer some sort of bar support program? So we'll be able to see how that relates to some of their experiences as well. Are they participating in a bar prep program, and if so, what kind? And then also we have a number of behavioral intentions, like whether they're going to be studying with study groups or if they're going to be studying by themselves.
Did you have something in mind that you would want to see?
I know that some of us have been collecting data that the bar review courses have about how much of the work they do.
Yes.
And we're seeing very strong correlations there.
Yes, yes. And we saw that in the focus groups, actually. When we did the focus groups, after students sat for the exam, they were talking about, how much of the course they could actually complete. And they knew that completing the course, every student in that focus group knew that the degree to which they completed the course was predictive of whether they would pass. What was problematic was that many students couldn't complete the whole course because they were either working or had outside demands or that sort of thing, which added this kind of psychological pressure, right, to them during studying. And so they were really given, it was the opposite of Dunning-Kruger here. They were like, I thought it was 50-50 whether I would pass, when we actually know the odds are even worse than 50-50 for passing the California bar. So, I do think that that's one thing. We have not collaborated with the bar passage companies, the prep courses, to get those data. That would be great to have.
I had another question. I know that you want real feedback from students, but have you also spoken with people who teach bar or do academic support? Because I know that that's what I teach, and a lot of this is stuff that we know. We try to convey this to the students. So, as a supplement, have you considered talking to people who do bar support?
Absolutely. And so from a number of angles, actually, one of the people who was very helpful early on actually is Rodney Fong, who does a lot of work in the area, and also Sarah Berman has been really quite helpful. One of our team members is Liz Bodemer as well, who actually does academic support at IU and has that network. And so through her, we've been able to do so, and also in presentations along the way and gathering that feedback. That's been invaluable, especially as a kind of check-in or feedback confirmation on some of the things that we're finding in the focus groups and so forth.
And Victor's presented this at several legal education conferences where a lot of support individuals attend, just to gather feedback on this as we were designing the program.
And that was incredibly helpful to know when you're getting kind of confirmation from multiple different angles that these particular concerns show up again and again, and then the question becomes what can be done to navigate around them.
Are the participants told that they have a 50% chance of being in the control group or not?
Yes, that's part of the consent process that's approved by the Ethics Review Board. Thank you.
What's the deadline for people to sign up this time?
So the deadline this time, the window for registration actually coincides completely with the California Bar's registration window. So as long as your students are enrolling in the California Bar before that window closes, which I want to say is in early June, they can still register for our program all the way until the very end of that window.
They actually even have a little extra time this time because the normal deadline falls on a weekend. So they have through and including June 3rd, but as we always tell students, please don't wait till the deadline if you can help it.
Yeah.
If there's a question for Stacey.
More practical. About how much time during the summer bar prep does participation in the program take?
Oh, that's a great question. So it's 45 minutes.
Oh, so it's just that initial 45 minutes?
Just that initial 45 minutes.
And then when they get, the students in the treatment group, then is that included in the 45 minutes?
So the program itself is 45 minutes. So those that are able to sign up earlier, so during the window of the timely registration process with a little bit of time in May, we're going to be releasing the program on or around May 21st. That's the first wave. We'll also have a second wave that's going out for everyone who signs up essentially afterwards. And it's just that 45 minutes. That's right.
Thank you for having us. We appreciate it.
Thank you.
Any other questions? So what we'll look for from you as we go forward is when we do the reminders to the students. How's that? Okay. So one of the things we'll look for from you, for those who have come here as participants, and we'll be sending widely to the deans in general, is we'll let you know when some of these reminders go out, so that you can encourage the students. Or is it okay to encourage the students who have signed up but maybe have not clicked on the link? Is that something that the deans can do?
Yeah, yes, I think that what we can do is we can work on some language that the State Bar of California can send to some of the deans. And if you do have students who have registered for the bar exam, you basically can encourage them to watch out for the State Bar's emails, because the State Bar will send them emails. And then if they'd like to participate, they're more than welcome to do so.
Yeah, the links to register are in those reminder emails sent by the State Bar.
One thing that we didn't say is there's no cost, there's absolutely no cost to participate in the program.
Thank you.
Thank you. So we'll be covering a lot of ground today. We'll be moving to a new area at this time, the area of moral character. How about that? Okay. Okay, so we'll be moving to a new area, the area of moral character. We'll have staff talk a little bit about some of the initiatives that are going on in the office and some of the ways that our new AIMS computer system will be changing and is already changing the way that you'll interact with the bar, and the way students will as well. And then we will be having a guest speaker, Debbie Makamal, from the Stanford Center on Criminal Justice, talk about the role of rehabilitation and strategies for students who may have prior criminal records.
Do we have the fingerprint, Michael? The fingerprint? Do we have this window? Is that it? Where's the?
Michael, that's in the main
Oh,
slide
okay.
set.
Okay. So I should go to the main slide.
Oh, yeah. Yeah.
Okay. So where?
Okay.
Oh, I'm sorry. There we go. Nope, that's not it.
Oh, we had it.
We'll be with you in a moment.
I think it just moved up the main. There you go.
Oh, okay, I think we're good. Good morning, everyone, and thank you for joining us. My name is Mark Torres-Gill, and I'm the Assistant Director of the Office of Admissions. And I think that we also have on the phone Tara Clark, who is the Program Manager for Moral Character Determinations. Before I introduce our next presenter, we have just a few updates. Just take a couple of minutes of your time on moral character and some items that might be of interest to you. So, first, what I'd like to point out to everyone is that we're asking that the students wait to be fingerprinted until after they submit the moral character application on the new admissions application system. The students will receive an email with a live scan form after they submit their moral character application, and that LifeScan form will include an associated case number. After they get LifeScan, then that LifeScan form will be uploaded to the student's case feed on their application portal. I'll show you that in just a minute. So what we'd like to do is ask that the law schools not host a fingerprinting day because the fingerprinting forms will be submitted will be given to the applicants as soon as they submit their moral character application. So this is a sort of a slide of the applicant's case feed. You can see here on the right-hand side the applications that the student will have filed. What they would do after they get their LifeScan form, they will go to the moral character application and click on the case file, and then that'll take them to their individualized case feed. And there's a paper clip in the lower left-hand corner, and they would use that to upload their LifeScan form to their particular application, and then that way we will know that they have in fact been fingerprinted, and we are waiting for the results. Also another note, another additional note for the law schools. The law school declarations that we typically ask in the moral character process will now be sent electronically. A little note to y'all, if you want a copy of the law school declaration, please print it out before you actually hit that submit button. Once you hit the submit button, you won't be able to make a copy of it.
Oh, and I had a special reminder to ask you to please use Chrome as your browser if possible when you're doing this. It is more reliable than Internet Explorer.
Yeah. Also, in another area, we have formed a moral character working group. This particular PowerPoint slide shows who those members are in the moral character working group. We'll in fact review the State Bar's current moral character standards and guidelines with an idea of updating them and making them maybe more clearly stating them. The members of the Moral Character Working Group are James Efting and Judge Torrealba and Larry Kaplan, who are members of the Committee of Bar Examiners. And from the law schools, from the registered law school, we have Michael Clancy, who's with Northwestern California, I believe, and Patrick Piggott, who's representative of the California Accredited Law School. And Patrick, I believe, is with Humphreys. And Meredith D'Angelo, who will represent the ABA accredited schools, and I believe she's with the University of San Diego, which segues nicely into our presenter, Debbie Mukamal, who is with the Stanford Criminal Justice Center, who also has graciously agreed to participate in our moral character working group. She is here today, and she is right now the executive director of the Stanford Criminal Justice Center, and which is a research and policy institute that concerns itself with issues related to criminal justice, to the criminal justice system. Before she became executive director, she was the founding director of the Prisoner Reentry Institute at John Jay College of Criminal Justice. She has her bachelor's from UC Berkeley and her JD from New York University School of Law. And today, Debbie is going to discuss the highlights of the center's current research concerning moral character in law school and state bar admissions as it relates to applicants and individuals with criminal records. So I'll turn this over to Debbie.
Hi, good morning. I want to first thank the State Bar for having me and for being such a gracious and effective partner. We reached out to the bar about 1.5 years ago about this topic, and they've been incredibly helpful in providing this information and also being open to thinking about new ways of looking at these issues. Interestingly, this project grew out of another big initiative that we were doing at the law school, which is that for the last 4 years, we've co-led an initiative a statewide initiative working with our public higher education institutions to increase college opportunities for incarcerated and formerly incarcerated people. And two of our students, of our law students, came to us as we were presenting on some of the work that we've been doing and the progress that we've made and said, this is all great, but what are we doing to get these same folks into law school? And I said, I don't really know. And so we turned that question into what we have at Stanford called a policy lab, which is a quarter-long, sometimes two-quarter-long class, usually small, 6 to 8 students, where we dive deep into a policy issue, hoping pedagogically to help develop the policy research skills of our students. And so we did that class a year ago. And the work is being culminated into a big report that we are releasing next month. So what I wanted to do today was to take you through both some motivations behind the work, our methodology, what our key findings were, and then if we have time to open it up to a few questions that I would love to hear from you all about. I also want to just start by saying that as we think about increasing access to the legal profession for people with criminal records, we are not at all suggesting that unqualified people be given access to the profession. What we are suggesting, though, is that there may be decision points along the way where we are inadvertently screening out qualified people because we're putting too much emphasis on the criminal record. So let me start a little bit with the motivations. It's probably not a surprise to most people in this room what our criminal justice system looks like, and that we are in a period of what we term mass incarceration. More individuals than ever before have a criminal record. Between 1970 and 2007, our incarceration rate quintupled, which has led to a current place of having about 70 million Americans who have a criminal record, which is about 1/5 of the US population, and 9% of adults have a felony. We also know that mass incarceration does not affect communities and racial groups evenly, that there, in particular, incarceration has affected Blacks and Hispanics at much larger rates of the population. I have here a slide that shows you just for the state of California, the orange bars are the state prison population and the blue bars are the state population, general population. So you can see that particularly for Blacks in California, they are being disproportionately affected by the criminal justice system, which means that if we rely on criminal records, that relying on criminal records for employment decisions, licensing decisions, and other kinds of decisions can compromise diversity and equity goals that we also carry as paramount. At the same time, we've actually had an explosion in the number of people with criminal records who are going to college. And this is really, and California really leads the nation in this regard, and it's really as a result of efforts of our public higher education system. Our community colleges, our CSUs, and our UCs are opening up opportunities for incarcerated and formerly incarcerated students as never before. So the map on the left is a state map that shows you all the places where an incarcerated or formerly incarcerated student now has a support program, either in a prison and or jail or on a community college campus in 2014. And then you can see how much it's changed in the last 3 years. That really, it's quite remarkable. To give you a little bit of a sense in terms of data, we have 5,000 college students taking face-to-face classes in our 35 state prisons. That's the size of MIT or Yale's undergraduate class. It's huge. No other state is doing anything like this. About 15 of our local jails also have community colleges coming in and teaching classes. And then on about 40 of our community college and CSU and UC campuses, there's a support program that is on the campus, helping both in terms of matriculating into the college, but also supporting those students while they're in college until graduation. So as more incarcerated and formerly incarcerated people earn college education, their professional aspirations rise. They no longer want to work at Walmart or McDonald's, very reasonably. And they're seeking professions they tend to seek professions, helping professions, which I'll talk about in a minute. And the bar is one of those professions that they are interested in. So to kind of get a handle on what was going on this issue and to understand it better, we knew that we needed to dive pretty deep. So this is what we've done in the last year and a half. We did a survey of 88 individuals with criminal records, trying to find out how they view the legal profession, what they see as obstacles to the legal profession. We analyzed the moral character disclosure requirements for all 20 ABA accredited law schools in California. We had interviews with 10 admissions officers at those schools. We had interviews with 7 student services officers at those law schools. We reviewed the moral character requirements of all 50 states, looking in particular at how California's policies, standards, and processes compare to other places in the country. We interviewed current and former California State Bar officials and CBE members. We had interviews with California lawyers who have been admitted to either the California State Bar or other state bars since having a criminal record. And we did interviews with California attorneys who advise on California moral character determinations. And finally, about a year ago, we convened an expert group of stakeholders, including folks like Mark, other former and current state bar folks, researchers, formerly incarcerated lawyers, advocates, law school admissions officers, law school student services officers to come to Stanford to have a roundtable last year, really trying to throw out some ideas, get a sense of where things are, where might we go, are there places of agreement in terms of what's working and where and what's not. What we found through all these efforts are that there are many barriers to admission to the legal profession for people with criminal records. And it's certainly not only the state bar that creates barriers. That those barriers exist, even as with other populations where we're trying to open up access. It's a pipeline issue, that there are individuals not even applying to law school, that our admissions offices at our law schools serve as front-end gatekeepers, that there's often not enough dedicated support for those students when they're in law school, and then that there are challenges to getting through the moral character determination that the state bar requires. In particular, I'm going to run through what some of those barriers are. We wanted to get a sense from the individuals who have criminal records about how they look at the legal profession. And so what we did is we surveyed 88 individuals. We admittedly did not take just anybody. We wanted to actually kind of cream and find those folks who were most likely to want to think about or were thinking about the legal profession. So we interviewed both college graduates and college students who are in some of these programs that are working with formerly incarcerated people. And we also did interviews there's a program that's based out of New York called Just Leadership USA. It's a national leadership program for formerly incarcerated criminal justice leaders. They do a year-long leadership development course. They've run the class for about 5 years. They have about 500 people who've gone through their program. And we sent the survey out to them. Those are folks who identify themselves as criminal justice advocates, might think about the law as one of the tools in their toolbox, potential tools in their toolbox to do that kind of criminal justice reform. What we found is basically that they're not even applying to law school. that there is a huge deterrent effect. So among the 47 people who responded to our question, why have you not yet applied to law school, over half cited the concern of passing the moral character requirement as one of the primary reasons why they're not applying. Stated another way, one individual said, I thought because I had a felony, there was no chance, so I never tried. So that's a huge part of this pipeline issue. We also looked at research looking at, that affects this area. And, there is not very much research out there. There's one study that was done, it actually should say 2012, not 2002. There's one study that looks at the usefulness of moral character as a predictor of future discipline. And there was no correlation between having a criminal record before you went to law school and whether or not you are more likely to be subject to future discipline. More importantly, though, there's a lot of criminal justice research in the area of what we term desistance, which is the likelihood of someone who has a criminal record when they look and match someone who doesn't have a criminal record in terms of their redemption time. Like, how long is it that someone who has a criminal record, we can feel safe that they will not actually recommit a crime? And that is really important research, because if we're looking and we're concerned about safety on our campuses, then knowing what that information is might prove relevant to how we look at an applicant's criminal record. Their age and the crime type are really important factors. We go through a whole analysis of that research, and I'm not going to take you through it because it's quite long and tedious. But the bottom line is that by 7 years that someone's committed a crime, they look like I might look in terms of my likelihood of committing a crime who's never been convicted at all. So that helps, right? Gives us a little bit of some concrete research in thinking about how to make these decisions. We also know that there's really relevant research about the productivity and the reliability of people with criminal records as employees. So there's been some recent research that's done showing that most managers and human resources professionals rank formerly incarcerated people, as good, if not better, than in terms of quality of hire as other professionals and other staff. Finally, there's a set of research that's relevant around what we call the wounded healer benefits. And that's that, and I alluded to this before, that people who have criminal records and have gone through and reached their own rehabilitation are very interested in giving back. They're interested in going into professions like human services, social work, working with youth. The law is one of those, because they want to be able to benefit others from the experience that they've been through and transformed into as a different person. And we also know that having someone who's been through, how important the peer model, how important it is to have peers as models as we're going through something, so that, if it's a first-gen student, having another first-gen student who's a couple of semesters or, a couple of years ahead of them, that is very, that can be very powerful. Well, it's very much the same with formerly incarcerated people. Having someone who's gone through been admitted to law school, gone through the moral character determination process and been admitted to the state bar can be very powerful for someone who's seeking to do that for themselves. There's recent legislation in California that reflects the spirit of all of this research. So most recently, we've passed in California the Fair Chance Act, also called Ban the Box, which went into effect about a year ago, and it requires employers to delay when they're looking at a criminal record and to really do individualized determinations and not have blanket bans against hiring people with criminal records. Really, again, reflecting some of this assistance research, reflecting like we need to give people a second chance. So let me take you through a little bit about what we learned from talking to and surveying the law school admissions folks themselves. And again, these are folks who are serving as our front-end gatekeepers to the legal profession. We looked at the disclosure requirements of 20 ABA accredited law schools in California, but we spoke with 10 of those 10 admissions officers from those schools. The frequency of criminal records comes up anywhere from 1 to 25% of the applicant pool, but it hovers around 5 to 10% for most law schools that we spoke to. The most common disclosures are substance related offenses, so DUIs, drug possession, that's usually what is coming up. We saw remarkable differences among all the various law schools in how they ask the question about an applicant's criminal record. Some are asking very wide, broad questions. Some are asking very specific and more narrow questions. We also noted that there's a huge difference between what the law schools are asking and what the state bar is asking applicants about a criminal record. So here I'm referring to, they might be asking about juvenile records or expunged records, arrests that don't lead to a conviction, that there's just a lot of variation. And so it puts a lot of responsibility on the applicant of him or herself to understand those distinctions very, very, very carefully and not fall into what we call the candor trap of then not answering the question completely and fully because they don't understand what's on their record. Do we have any criminal law practitioners in the room? So you've seen a rap sheet. You know how complicated a rap sheet is. A criminal law practitioner can barely review a rap sheet. Expecting an admissions officer, expecting the state bar, and expecting the individual, him or herself, to understand and to make those sort of very sparsely, I think some of those distinctions is difficult. And I'm not sure that we know why there's such a wide variety of differences between all those different forms that are required. We also asked admissions, when we asked admissions officers about why they're asking the questions that they're asking, what the purpose is of their moral character disclosure requirements, they really point squarely to the state bar's moral character requirement. They say that that's why they're doing it and how they're crafting those. They say that more specifically, when they're thinking about it, they will look to see whether or not they think someone will be able to be admitted to the bar. One law school pointed to ABA Standard 501B, which, as you may know, says that a law school shouldn't admit anyone who is unable to be admitted into the bar. Some of the admissions officers cited to safety, liability concerns, really a desire to assess an applicant's judgment. Those were also motivations for the moral character disclosure requirements. Half of the admissions officers said that they don't have a specific policy for how they review applications that have conduct. And only one mentioned having a specific reviewer who has some kind of who's designated for criminal conduct disclosures. So what that means is that you've got admissions staff that are being tasked with really trying to parse through complicated criminal justice background information about an applicant and trying to figure out its relevance to their ability to succeed in law school, to pass the bar, to otherwise whatever other concerns the law school may be bringing to the table. We next did interviews with the student services officers to try to understand, once an applicant has been admitted to the law school, what happens to that student, what kind of support are they getting from the law school. Again, huge variation in how admissions and student services communicate with one another about the needs of those students present. Some are communicating that right away. The registrar is making some of those connections, and some are very siloed. And so they're really relying on self-disclosure of the students to come to student services and talk to them about it. Most student services will discuss the moral character requirements with law students sometime during the first year. There's a lot of variance in how they then support law students with the moral character issues. So you have some law schools where there might be a dedicated staff or faculty member who's going to help those law students navigate some of those the moral character application, put together the rehabilitation package, and some for whom it's the student or her own. There are some other unique issues that arise when we have students who have criminal records that I just want to flag really quickly. One is that, this came up in the roundtable that Mark and I participated in last year. Students who have criminal records can feel very isolated in particularly criminal law classes when a professor is talking about defendants and felons and, prisoners and stuff when he or she has gone to prison him or herself and doesn't know how to communicate that to their faculty member, what kind of stigma that might have. And then more specifically, there's some issues that arise around private sector employment. I spoke to one law graduate who during his second year, second summer, got a great private sector job, got an offer at the end of his summer, and was very unclear when and if he should tell the private sector employer about the fact that he had a criminal record. It wasn't otherwise asked of him up until that point. He knew that having a criminal record would likely either delay or limit his ability to get admitted to the state bar. And he wasn't sure, and there were no career counseling staff at his law school who helped him navigate through that unique issue. Finally, I just want to flag a little bit about what we found with the California State Bar policies. Here, I'm just going to flag one issue, which is the declaration form. The declaration form that the law schools receive asks you to indicate information about an applicant's criminal record. That's actually different information than what the applicant, him or herself, is asked to report to the state bar. So again, like trying to figure out, should there be more alignment there? Why are we asking two different kinds of information from the law school versus the applicant, him or herself? Is it a gotcha thing? I don't think so. Is it just, we haven't standardized those questions. There's also legally imprecise questions on that declaration. I went around to our criminal law faculty and asked them to tell me what this means. The question on the declaration is, has the student been arrested or otherwise charged formally or informally with a violation of the law? I'm not really sure what an informal violation of the law is. Maybe someone in the room knows and can share that with me. But again, just trying to make the questions a little bit more concrete on what we really need to know would be helpful. The report includes a number of recommendations that we see as ways to expand access to the bar for qualified applicants with criminal records. They do not fall squarely on the state bar. They actually, it's quite a lot that in the entire pipeline that needs to be done. I think that we need to be developing that pipeline of those college students who have criminal records and college graduates, and really addressing head on that deterrent effect of them thinking that they actually won't get admitted to law school or to the state bar. I think that there's things that we can be doing with the admissions, on the admissions side at law schools, like what kind of professional development do our admissions officers need to be able to, if they're going to ask about a criminal record, how are we using that information? What should they be using? One thing that the admissions officers told us is that they'd like to see a lot more guidance from the state bar in how a criminal record will be used against an applicant when they're going for state bar admission, because that will help them on the front end in making decisions. What kind of support can we be offering to students when they are in law school? What kind of support, including, helping applicants for the state bar with their moral character applications? And then, what kind of development and what kind of standards should we be thinking about on the state bar side? And I don't know if we have time for questions. I know that I've pushed you into your lunchtime, but these are some of the questions that I was curious to ask you as a group of law school professionals. Should there be more alignment among all of the law schools in California and the kinds of questions? I know it gets complicated because not all of our students are going to be applying to the California State Bar, but a majority are. Should there be alignment between the questions that you as law asking and what the state bar is asking the applicants themselves? What kind of professional development should we be making available to all the decision makers, the admissions folks, and the state bar, the committee of bar examiners? Should there be a washout period after which, a criminal record should not be considered relevant unless there's extenuating circumstances? And then should the California State Bar make data available so we know more about what this deterrent effect is? Do we have applicants applying every year? What percentage of those applicants with criminal records are getting admitted? Do we have profiles of who gets admitted? Unfortunately, we have very little case law on this. And the Glass case, which some of you may know, is not a very helpful case law. It's a pretty egregious case and doesn't really help us with the sort of most of the kinds of applicants I think that we would be seeing. And then, we're curious and are eager to do and take on any additional research that you might be thinking about.
And we do have time for a few questions, and we'll encourage this discussion to continue through our lunch period.
Thank you for this information. One question that I had was, do we have information about attorneys who have been admitted to practice law who did have previous records of criminal convictions, and whether or not they have encountered moral character issues as attorneys? I feel like that would be informative as to whether there is a correlation between having moral character issues in practice if there were individuals who had records of criminal convictions prior to being admitted to practice.
So, we know the answer is there's one study that's been done that looked at, folks who had moral character issues when they applied to state bar admission. It's a study that was done out of Connecticut, and then whether or not there are, future discipline issues, and there was no correlation with criminal records. We know that there are many attorneys in California who are licensed to practice who have criminal records, and then I know that there's been recent fingerprinting of our membership, and that I don't know very much about this topic, but that it turns out that we maybe have more than we thought who have criminal records. And I don't know how the state bar is going to deal with that issue, but that's not my job.
Yeah, and I don't believe we have that kind of data yet, but it would be interesting data to collect. But right now, I don't believe we have that available.
My other question was in regard to having more uniformity among the questions that the state bar is asking of applicants, and then the questions the state bar is asking of law schools during the certification process. Is this something that is forthcoming from the study? Is this something that the state bar is looking at as to why there is a difference in questions that the law schools are asked and the questions that the students are asked?
Yeah, and thank you for that. And this is information that was just pointed out to us. We have a moral character working group that we're forming, and Debbie is going to be a part of that. And I think that we have now a forum. I think that we can start asking ourselves those sorts of questions. The kind of what we do in moral character, the application process, all of that is always a work in progress. And so, we appreciate it when, concerned individuals bring up issues like that for us to look at. There may very well be a good reason why, there's some disparity in the way we ask those questions, but certainly it's something that, I certainly would like to look at again and make sure there's justification for it. And maybe there's a better way of doing it. I totally get that.
Debbie and I were talking about this a little bit yesterday too, because, and these were my words, not hers, it really sounds like the fact that we're asking the law students for asking the question one way to the law students and asking it another way to the law school, it just feels like it's an attempt to trip somebody up, right? And that's never the intent of what we're doing. So I would suggest that our moral character working group is going to be working very hard, and they'll be looking at everything that we're doing in moral character. This might be something that we can accelerate the timeline on and look at the consistency, look at things like, I think informally wasn't modifying violation of the law, it was modifying informally charged. But I don't know what that means either. Yeah. So I think these are things that we might be able to correct sooner rather than later as we move forward on this process.
I wonder if the questions that the bar has asked of law schools has informed the questions they ask on their applications, because it seems that that's information that's important for us to gather, and that has in that way informed the questions we asked. That was one thought I had. I was talking with one of the deans yesterday who was concerned because they don't, at his law school, collect arrest information, but we ask the law school for arrest information, though we're not asking the student. And he said that he was worried that his response, that he didn't have that information, would somehow reflect poorly on the student. And they don't have the information because they don't ask it. And obviously, nobody's going to be getting negative marks because the school didn't collect the information. So that certainly shouldn't be something that the school is concerned about. But I absolutely suspect that for those schools that ask the arrest information, part of the reason they do so may be because we're asking for it. But as Debbie pointed out, the schools seem to vary incredibly in terms of whether they're asking it or not. So some are less compelled to get that information that's being asked by us than others.
So I wanted to thank everyone for their attention and also for allowing us to cut into lunch. Debbie.
Hello, my name is Debbie Manning. I'm on Board of Trustees, but in my prior life, I did background investigations for the State Senate. And one of the things that I came across in looking at, you said, the criminal records of people, is that a lot of times people would have something on their record that looked like it was an arrest, that they were arrested for something. And then I would call DOJ and I said, he's adamant that he was never arrested. But what happened was they could have been in a situation where there was a bar fight or something was going on. They were sat in the back of a police car and their record ran to make sure that there weren't any warrants for them, but they weren't actually formally arrested and brought into jail. They were just let go. Just the fact that they were sat in the back of the police car will show up on their DOJ record that they had been arrested, because when you look for, okay, did they go to court, what were they convicted of, and there's nothing there. But there's this arrest, it looks like they were arrested sometime. That's what that was. And so, yeah, the criminal record itself, like I said, you really have to, you can't just go face value on some of the things that they'll have on there, because a lot of times it's not that they were really arrested, they were just happened to be in a situation where the cop said, yeah, just we're putting you in my car, gonna run you though, to make sure you don't have any warrants. But they weren't really arrested. So there's some of that goes on too.
Okay, so I want to keep the mic still. But beyond that, I want to thank everyone for their attention and for allowing us to continue the discussion a little bit into the lunchtime. And at this point, I'll let Joe know that we can turn off the tape to break for lunch. But before we break, looking for the sign from Joe. Yeah. Before we break, of all encourage you to meet someone you haven't met, and there might be some folks coming to meet you. You have met the State Bar staff at the beginning, but I also want to take a moment to point out had a nice time meeting each other and continuing the discussions from this morning. We have another jam-packed afternoon for you that will continue on till 3. And we're going to begin with a discussion about law school retention for students of diverse backgrounds. This panel will be chaired by Helen Hong, our Director of Access and Inclusion, and I will invite her to introduce our distinguished panel. Thank you, Helen.
Good afternoon, everyone. Thank you so much for eating so quickly, and hopefully you're not in a stupor, so please remember there's coffee and soda still. Thank you for spending time with us this afternoon. I know that many of you are in the midst of finals and graduation, so we are very appreciative for you to be here. I know that the Office of Access and Inclusion is broadly vague, and it's actually newly formed title for our office. For those of you who are not familiar, the Office of Access and Inclusion has 3 major prongs. The first is providing legal services for legal aid organizations via the IOLTA revenue. For those that don't know, in 2019, we'll be distributing more than $62 million for free civil legal aid organizations throughout the state of California. Along with that, the office is focused on integrating diversity and inclusion initiatives through the Council on Access and Fairness and the Board of Trustees, as well as addressing other access issues for Californians so that they have a real connection to feeling that their legal issues are being met when they're interacting with our legal system. I'm really proud to be here, partly because COAF, the Council of Access and Fairness, was the seed idea for the productive mindset and bar studies exam. 3 years ago, they addressed one of the major issues to focus on was either bar exam preparation or mentoring, and the Board of Trustees advanced the productive mindset, what you saw today. So with that, I want to introduce the chair of the Council on Access and Fairness, the former also chair of the Board of Trustees, Judge Holly Fujie.
Good afternoon, everyone. Thank you for staying awake. I know it's tough in the afternoon after lunch. Do we have you want to move on to the? Oh, yes. Yeah. All right. So we're looking at the goals of today's discussion. You can read that, but really what we're looking at is this: getting past the idea of people getting into law school. How do you retain your students of color in your law school so they graduate? How do you support people so that they feel comfortable, they go forward? I thought it was very interesting to hear the discussion about the Productive Mindset program and listen to the one comment that was made that once you look at the issue of how you deal with people's mindset when you're preparing for the bar, that we need to go back and look at how people get through law school. And that's a major problem, and everything that they said with regard to the problems that people have psychologically with getting through the bar exam apply even more when you start law school. So how do you get them from starting law school until the point where they take the bar exam? So we're going to be having a presentation by Helen Hong on attorney population, on law school data, current activities. I think a lot of people know basically the situation we're in. It is important for all sorts of reasons for us to retain our minority law students and get them through to practice in the state of California or to practice wherever, but coming out of our law schools. And I see it myself as a judge because I want to see a diverse population representing clients in my court. I sit in a civil unlimited court in Los Angeles, and I will tell you that we do not see representative samples of the population sitting before me. I sat for 4 years when I first went on the bench in family law, where I would say 60-70% of the population of the litigants in front of me were Hispanic. And I think I saw maybe in 4 years maybe 10 or 15 Hispanic lawyers representing them. And then when it comes to going onto the bench, you need to have those lawyers. You get the law students who go and have to pass the bar exam, become lawyers, they start practicing, they're successful, and then hopefully at some point that becomes the pipeline to the judiciary so that the people on the bench look like the people who appear in front of them. Again, with my family law experience for 4 years, there were no Latino judges on the Los Angeles Superior Court family law bench. For most of the time that I was there. So I think it really, it sort of goes without saying that it's important that we have that pipeline all the way through, but it's at your level, at the law school level, where we see a lot of leakage along that pipeline, and we want to figure out what we can do. And we're going to be hearing from 2 schools which have tremendous presences on that, and we're really excited to hear from Elizabeth, I'm sorry, McGriff. I was thinking, I wrote really badly. Elizabeth McGriff from UC Hastings, and also Cindy Thomas Archer from Loyola, both of whom are going to report on the very exciting programs that they have. And then we're going to be spending a lot of time here talking to everybody out there in the audience about programs they have, programs they might be able to have, programs they've been thinking about, so that we can really use this as an incubator for the types of programs that are going to increase the retention of minority students in law schools throughout the state. All right?
And I just want to emphasize, and thank you for continuing my role, which was the full introduction of the panel. I only made it to halfway of the table. I apologize. The State Bar is engaged with access to justice and diversity because it is in our mission statement adopted by the Board of Trustees in 2017, which really focuses on greater access to and inclusion in the legal system. The legislature also adopted the statutory mission last year as well. And what we're really hoping to talk about, not just by programs, but how do we move the needle? Looking at data so that we can eventually get to the fact that our statewide attorney population reflects the rich demographics of the state population. This is an audacious goal for the State Bar, and we understand that it's not going to happen in our 5-year strategic plan, but we can really make progress to achieve this goal. And so some of the items that the State Bar is really focusing on is what we're talking about today, identifying the means of supporting law school programs to improve retention by the end of this year. The other thing that we're working on is working with the California accredited law schools and registered schools to develop enhanced demographic reporting requirements, which we currently don't have, to see what we could be doing better to advance more law school graduates. So very similarly to Debbie's slide, you will see how does the State Bar population compare to the adult population in California. The darker blue bars are the attorney population, and the light blue is the California general population over 18. And you will see that our profession currently is majority white and majority male. But where you see the largest disparity is within the Latino population, only having 6% of the attorney population and 35% of our entire state population. And with our new enhanced demographics of My State Bar profile, you will also see that 6% of our profession identifies as non-conforming, non-binary gender. But when we look at the data a little bit deeper, we see that in California, for every 100 white students, we are only graduating 10 African American students, 30 Latino, and 28 API students. And when we look at the data that we get from the ABA, we see that from entry to exit, we're seeing a disproportionality of attrition of students of color. And the reason why we're looking at enhanced demographics from the California and accredited schools is that we know from their enrollment data that these students, that the schools are actually much more diverse, but we don't have the correlating data of the graduation data. And so that's something that we're working on with the CS bars. And we hope if you are interested in participating with us to reach out. You'll get my email at the end of this presentation as we discuss this further. So passing it back on, what we wanted to do and what admissions sent out to many of the deans, and hopefully you received this as well, is information on what programs that you have to retain students from diverse backgrounds. And the Board of Trustees adopted diversity based on government code, looking at race, gender, ethnicity, veteran status, and age. Sorry. And so we are looking at that in the same way that judicial profiles are also categorized. And so many of you filled out forms. We got about 24 responses in terms of what programs that they have. And from that selection, we highlighted 2 schools who are here today, Loyola Law School, as well as UC Hastings, that are focused on not only retaining, but collecting data on how their program actually advances to graduation. So with that, I'm going to pass it on to my school. I'm very proud of. I'm proudly a law school dropout. Full-time worker. I had a dropout once from the East Coast, and then I worked full-time at Loyola. And so I'm happy to have Cindy Archer here.
Thank you. And we are definitely, I was excited to see a Loyola alum was putting this together because this is something that we've emphasized. So as I mentioned, I'm the Associate Dean for Clinical Programs and Experiential Learning, and at Loyola, I also support public interest in a lot of our diversity efforts. So I was really encouraged to be a part of this and the ultimate partnership. So we were asked what we do, why, and whether we assess it or not. So I'll try to highlight things and answer those 3 questions about the things that I'm able to highlight. So I did print out what was going to be my PowerPoint slides, really, so it's an opportunity for you to take notes if you want to. But skipping to our early support and intervention programs. So I'll start with the 2 things I want to highlight are the pre-matriculation program that we've had for. So I just confirmed with one of our former associate deans who is retiring this year. Loyola has a program called Summer Institute, and it actually started in 1982 with the specific intent of supporting marginalized students, many of whom didn't come in with markers that indicated we should give them further support. And that could be LSAT or otherwise, or it was they might have been first in their family to go, hadn't been out of school for a long time. But in that program, essentially, it's 3 weeks before school starts. They come to classes 3 nights a week, and we were very intentional about night, realizing a lot of these students need to work up until the day classes begin. And it's preparation, for school, a very extended orientation to some degree. One of the things that I think makes this unique, unlike some other schools that do this, is we try to include the families also. And you'll see that as a theme in some of our other programming, with the recognition that particularly students who have family traditions, where the family is very involved in their education, especially when they're first in their family to go, the families don't give great advice a lot of times. And that, I saw this myself, when you're talking to students, why are you working when we've told you not to work? Well, my family. My family has a family business and they need me to be there. Or why is it that you're going to this party and you have an exam the next day? Well, nobody misses grandma's party, right? So part of the intent of this is we have not only a reception for family with a panel of prior family members, but the beginning of that reception starts with we send the students home with 2 cases for their parents, siblings, and roommates to read, and then they do a mock lecture with the faculty member. And the idea is to get them to understand how hard the process is going to be that their students are going to go through. Like, this is not just reading something from a textbook. And so for a lot of them, it puts them in a different context. So we really do try to support the families also. The one other thing I'll note on here is, so I know a lot of schools in their academic support or success have classes for students who have not done very well in the first semester. And so ours is a 1L elective. What we tell students is you need to earn an elective for spring semester. And you do so by getting a certain GPA. And those who don't earn that elective get the opportunity to be in the privacy torts class. And the class was actually created by somebody who's in the room here, director of our bar program. They do it second semester in lieu of their elective. And the students create a real community around it. The first day they walk in, they absolutely hate it. They're embarrassed that they have to be there. But we really make an effort to create community around it, as well as taking them through the skill and substantive class. So on those efforts, we engaged our institutional research department at the university to help us do the assessment over this. And we've been collecting data, Susan, for like the last 6 or 7 years on those programs. 7 or 8 years to find out not only did it have indicators regarding bar passage, but retention and increase in GPA. That was an important marker for us that between their first year and their second year, their GPA increased. One, because GPA is the best indicator so far of bar passage. But two, we don't want to put students through this without showing them that in the end, there was a benefit to them right then and there, not just what would happen on the bar. And so far, the indicators have been good on both of these programs with the research that we've done, and we continue to collect data on that. So our first generation student programming, that's only about 3 years old. And like many other schools, we have panels and presentations from students. One of our panels that might be a little unique is we do a panel of faculty members who are first in their family to go. And I actually have one of our former deans sit on the panel every year to tell students, I screwed up, I was first to go, I drank wine at my law firm interview, and I still became a dean. So, we're trying to tell them everybody can make it. But this is another program where we bring in family. So if you were first in your family to go to law school, doesn't have to be to go to college, we invite you to a brunch during orientation. And again, we have panels of alumni and students who are there. And we bring back parents, spouses, roommates of alumni to come in and talk about how to support your student without smothering them, what they can expect from their student, that they can expect their student to cry after midterms, even though they've never cried one day in their life about school. Because that's the challenge a lot of people, again, in communities have, is they've always excelled, they come to law school, it's hard, their family doesn't understand, they put undue pressure on them. And so far, we have gotten tons of family members who write us to say, thank you so much. Like, I actually feel like I know how to support my student now through law school. And they've been very encouraging about it. Because we just started it, we're just starting to collect the data on whether there are indicators of where this will specifically help us in our retention efforts, because that was the intent of it. Our bar programming, I don't know that it's unique in terms of supporting students for the bar exam. What I think is unique in supporting marginalized students or students who are underrepresented is that our bar program is very much one-on-one in terms of counseling. And that's from the second year of law school through like the second and third time that students take the bar. They know they can meet with an individual bar counselor every step of the way, from which bar prep course do I use. They'll do assessments on them on what's your learning style and skill, and talk through the benefits of different programs. And we do that no matter how many times a student takes a test, they can always come back. Our bar counselors sit down with them every semester to talk about their course schedule, to talk about, do I need to actually take every single bar class? Can I do an externship? And that has been, I think, very helpful in making students who feel challenged about their presence in law school feel like somebody's paying attention and feel very supported. And that's the feedback that we get from students. And yes, we have done assessment since we instituted the formalized bar program and looked at every aspect of different type of student there. And we have seen positive effects first time, but we've seen even significant positive effects on second time takers. And I think that's because of the individual counseling of helping students know that, you know, it's okay to take it a second time and we're going to be there with you through it. But we have seen positive effects on both of those. In terms, I was asked about this, and I'm not sure that this is specific, but I do think the public interest, public service support. So a number of students come in wanting to do that work, and I think very, very challenged to do so because of class and other issues. And so we work very hard to provide funding for students and to provide direction from students right during we start the second semester of their first year, reaching out to all student groups, reaching out to all students to let them know there's summer funding available, that there's loan payback assistance available, and Loyola supports specific postgraduate fellowships to help students get through that. And to ensure that these programs do support students across the board, our dean actually created a task force last year to review all of our programs, ensuring that they were supporting all students across the board and not particular ones. And it was students, staff, and faculty on that task force. And it was helpful, eye-opening, and we have instituted a number of changes to ensure that the support is going to as many people as possible as a result of that. And then finally, I'll mention some new efforts that we are either recently instituted or about to institute. Loyola just last year created the Coelho Center for Disability Rights. Tony Coelho is one of our alumni, an alumnus. And what's important about this program, when we're thinking about diversity, and this, you know, wasn't in your records, one of the populations that is lowest in representation is people with disabilities in the practice of law. And one of the pillars of the Coelho Center is to increase the representation of people with disabilities in legal practice. And this summer, we're going to host the first summer program for college students with disabilities who have an interest in law, hoping to mentor and encourage them to enter the practice. And that same center has helped us in thinking about the services that we provide. And the last couple of things I would say, I think, are efforts that make our campus as a whole more welcoming, and that is probably the most significant thing we can do for retention. We instituted a lot more training for faculty and staff this year in terms of, you know, how to address students in the classroom with disabilities, LGBTQ. We had speakers come and talk about stereotype threat and how does that impact students in the classroom.
Detected that a minimum number of lines are connected to this conference. Do you want to continue your meeting? Press 1 to confirm.
I think we got that. Okay. The other thing that's been helpful in this thinking about broader efforts is partnering with our main university. So I'm working with them to do a climate survey for the law school next year. And one of the reasons in doing that is we realize you can do a lot of things, but there are particular needs that every school has. And one of the ways to find that out is actually to do a formalized climate survey of your school that helps you figure out what are the challenges that your population is facing. So our broader institution, University Intercultural Affairs Department is going to help us with that effort this year. And then one last thing that I did myself this year, we had a diversity training for the 1L students, and there were a couple challenges raised by some students. So I thought, you know what, I'm just going to go talk to them. So I had meetings with each section, and then I said, I'm going to host a series of individual lunches, no more than 20 students. I'm buying lunch, you know, how much I am there. And I said, I just want you to come and talk to me about what it feels like to, what do you think we're doing right, and what do you think we're doing wrong in terms of making us a welcoming environment? They were wonderful, wonderful opportunities where students said, I just thank you for doing this. Like, I don't feel like I've had a place on campus to just come and talk about what my experience is like. And not that Loyola's doing anything particularly wrong. And I did get some things that were very easy to go back and work on. But one student said, I mean, just to share this with you, I carry in my breast pocket my student ID everywhere I go. Everywhere I go. And he said, none of my friends, nobody knows why. And he said, when I was an undergrad, the campus police picked me up and said, what are you doing here? You can't be a student. And he said, I came, I worked for a while, I came back to law school, and I said, that'll never happen to me again. So I do not walk on this campus without my ID. And he said, I have not had a chance to tell anybody about that. So you hosting this lunch with this group of students, I can now it's just freeing to talk about that. And makes me feel like Loyola is what they said they were when I came for orientation, just doing simple things like that. So, and there were a number of other similar stories that students shared that I thought made them feel welcome, included, and part of the environment.
I'm going to turn it over to Elizabeth McGriff that has a really robust formalized program at UC Hastings.
There you go. Good afternoon. Thank you. My name is Elizabeth McGriff, and I'm the director of the Legal Education Opportunity Program at UC Hastings College of the Law. I'm also the Equity and Inclusion Advisor to the college. I'm a UC Hastings grad, and I'm also a LEOP alum. The LEOP program is actually quite legendary. We are in our 50th year, and LEOP was created to provide access to a top-tier legal institution for students who have overcome significant disadvantage and adversity. And in the process of doing that, as a practical matter, you do end up with a more diverse student population. And generally speaking, the goal at our institution is for LEOP students to constitute approximately 20% of the school population. So, we're about 900 or 330 students per year. So I generally have been bringing in, for the past 5 years, I've only started in December 17, but for the past 5 years, we've had about 45. I just finished my first full year admission cycle, and we will have 80 plus students coming in the fall. So our population has actually doubled in 1 year. LEOP has sort of three overarching aspects to it. The first is admissions. So when a student applies to UC Hastings, they can check a box that says, do you wish to apply to LEOP? Occasionally, I think there are some students who miss it because for whatever reason, they don't know about the program. And what happens is then we have a committee that evaluates those applications, and I take a gander at them before they go to committee. And we are looking for students who are obviously high achieving and high potential. One of the myths that I like to debunk is that the metrics for LEOP students are dramatically lower than for other students. It's simply not true. When you look at the median for the class that's incoming this year, they're almost identical in terms of undergraduate GPA and LSAT. And there's a huge range. But we're talking about students that have really just outrun every obstacle. They have come from food, job, and opportunity deserts, educational deserts, housing disadvantage, parents who are disabled, working 3 jobs and going to school. I read an application of a student who went to Reed. She took the LSAT and got a 170 the first time. She didn't necessarily have a super high GPA, but I knew there was a story behind that. It's because she was working 3 jobs, but she went to a selective institution, and she was really a classic good candidate. What I have noticed with admissions is that we often get applicants who come from top-tier institutions. They have high GPAs, but there is a great disparity between their on-paper objective metrics and their actual ability to write well. And what I tell my students all the time is law is one of the 3 learned professions. Two, this is a profession of words. It is a stock and trade of what we do. So if you're not good at it, you need to work to improve on that. So one of the hallmarks of my program is making sure that students are working on their writing abilities and assessing that writing ability when they come in. So once students are admitted, we start with the week-long orientation. And it's amazing. We do a family reception with the students in the Sky Room. It's just incredible, and we have a huge turnout. And the beauty of that is the students get the opportunity to meet one another, and it's very relaxed. And they also get to meet each other's families, and they get to see all the similarities. This particular class that I had this year is very special. They have a nickname. It's Triple E for engaged, effervescent, and energetic. They basically eat up anything I give them. But what is particularly unique about this class is without a lot of effort on my part, they were very cohesive from the get-go, and they remained cohesive even after the first semester grades came, which was particularly inspiring. And they just finished their finals today. So during our week-long orientation, it's very holistic. So we have some academic components where we do some case briefing, case analysis, exposure to what they can expect. Last year, I flew in Pete Wendell from Pepperdine, who was amazing, and does a workshop for students from under-resourced backgrounds, from Harvard Law to other schools. And he flies out and does this remarkable 2-hour session with them, and sort of unlocks some of the keys to how to look at a case, how to evaluate things, and demystify a lot of what law school is about. And the students just adored him. We have faculty come in. I have all the administrators come in and speak to the students. And what I also have found, having worked with students for many, many years, is that they often have great native intelligence, but they are fundamentally lacking in strong executive functioning skills. So I incorporated an executive functioning component to the orientation. I called it Getting It Together, and just helping them on how to schedule their time and how to manage their time, because as we all know, it's fundamentally different than college and how you can manage your time. I also know that when these particular students come in from challenged backgrounds, the gaps are significant. And even if they do well academically in school, they are in great jeopardy of not succeeding professionally if they do not know how to navigate the corridors, the academic corridors, the professional corridors, the social corridors. So I incorporated a component to the program called Corridor Competence, about the kinds of things that they need to know, including etiquette. Please eat from the left and drink from the right, and please do not order spaghetti when you go for your callback interview. And please be polite to the wait staff. And you would be surprised. I mean, these are some things that, if you are coming from a perch of privilege, that it's a foregone conclusion that you know these things. But it has been, I think, a great benefit to the students. So we do all of that in orientation. I also take them over to the Supreme Court. They meet with 2 or 3 Supreme Court justices and get a tour of the Supreme Court. And we have alumni come in and talk about their experiences. LEOP alumni are very, very enthusiastic. So it's easy to get them to come and talk with the students. So by the time they're done with my 1-week orientation and they go to the 3-day general orientation, they think that they are really quite savvy about the law school environment, and they are. So from there, what we do is once school starts, we hit the ground running, and we have weekly tutorials that are led by LEOP students, upper division students, under the supervision of an academic resource specialist. There are only 2 people in this program. It's me, the director, and I just brought on an academic support specialist within the last several months. And so we work together to develop the academic program. And then every Saturday, students have practice exams. They get feedback within a couple of days on those exams, and they have one-to-one academic counseling so that they can really hone in on where they have some deficiencies and improve their writing. And then I also figure out workshops that I plan to do during the semester. But I'm always willing to pivot if I identify that there's a need. Last year, I noticed that a number of the students were not passing the MPRE, which I found most concerning. So I worked collaboratively with the bar support director to develop an MPRE workshop. And we saw a big improvement in the students' performance there. So we also continue our academic support through the upper division years, and I collaborate with a lot of departments. I worked with one of the doctrinal faculty to create the first ever doctrinal faculty partnership for LEOP. So what that means is doctrinal faculty who are willing to come to the LEOP suite at the lunch hour, and they meet with the students, and it's just, the professors don't have to prepare, it's just an office hour. And it serves multiple purposes. One, it breaks down the barriers between a program like LEOP and the institution at large. It inspires students to interact with professors and be encouraged to go visit them in their office hours outside of LEOP. And it also folds in as community building because I provide lunch. I'm obsessed with Okay. Can you hear me? All right. So,
It's the one
did
that's
you
lit.
realize-
It's the one that's lit.
One's lit up.
Ah, okay. All right. Well, we'll get back on track here. But I'm obsessed with providing food for the students because I've always known, having worked with students for many years, in addition to being a law practitioner, that for particular populations, food insecurity has been an issue for many, many years. And you can't expect students to produce if they don't have the nutrition. But anytime you're breaking bread together, it's going to build community. So we do that, and we also do academic workshops on exam writing, multiple choice, and we do work collaboratively with, UC Hastings also has just a general academic support program. But under our entire umbrella, we're called OASIS, so that's the Office of Academic Skills, Instruction, and Support. So that's general academic support for the entire student population, and then LEOP. And so I try to run a high-touch program. So I do a lot of professional development with the students. They're in my office all the time. We're doing mock interviews. I help them prepare for a trial team, moot court. It's basically a one-stop shop, but we really work on the academics. And this year, the 1L class, that's our 50th class that just finished their finals, had the highest academic performance in the history of the LEOP program, and basically we're on par with all of the students in the general population. So that was a great success for us, and every one of those students had 3 to 5 job offers for the summer, and really good jobs. I mean, really good jobs. So they've been quite successful there. So I do a lot of work with alumni. I've had alumni mock interview programs, alumni mentors. I like to do what I call academic success coaching. So I pair up students very frequently with 1Ls with upper division students so that they're really in alignment with someone that they can talk to and get that kind of fundamental guidance that they might have trouble getting elsewhere. And it yields really great benefits. The students feel supported. And my philosophy is students don't care what you know until they know that you care. So you really have to, what I find from my programs is I roll up my sleeves and get in the trenches. I'm returning text messages at, 1 o'clock in the morning, emails. They often have emergencies, whether they're financial or social emergencies, or they need guidance about how to deal with the family problem. So it tends to be very wraparound. I also work closely with our disability resource program director because there's some overlap there to make sure that students have good outcomes and good accommodations, and to also guide them through seeking accommodations for the bar, because we want to make sure that if they've had accommodations at school, ideally they can continue to get those for the bar exam. But there's a whole lot more. We're going to have a huge celebration this fall for the 50th anniversary. One of our most prominent alumna is Kamala Harris, also Jeff Adachi, who we just lost and was a big, huge fan of LEOP. But we have more than 3,000 alumni, and it's a remarkable program, and we're just having a bumper crop of success. However, I like to keep my foot on the gas, so there's always room for improvement, so I frequently survey the students to get feedback, and this 1L class always gives me a 100% return rate on surveys, which is unheard of. So there's going to be a high expectation for the next class, but it's very helpful to get their feedback. What worked for them, what was helpful, what would they like more of? And, I just continue to do partnerships. I partner with the Career Development Office all the time. I do a 2L job, what I call 2L job search RX, because even though the 1Ls last year got great jobs, I don't want them to lose momentum. I have the 1Ls get an introduction to career services, and I have a 3L job search talk that career services comes in and does. So there's a lot going on in that respect, and in my capacity as Equity and Inclusion Advisor, we have a Diversity, Equity, and Inclusion Working Group. We've started a speaker series, and we are also working on a campus climate survey. And really, my push is to have immediate things that are really palpable to students to make them feel included, whether that's the artwork at the institution or ways to recognize students from diverse backgrounds. So the main thing that I think makes a difference for students is to feel that they have been seen. The African American student population from last year compared to this incoming class has doubled in just 1 year. And we do a LEOP breakfast. So last year we started a LEOP breakfast for families and admitted students. So we had about 18 students and families last year. This year we had 55 RSVPs and we ended up with over 100 people there. And it was great. I think we may have run out of food, but it was amazing. And I did a first ever panel called Thrive, How Families Can Support Students in Law School, which was myself, a LEOP alum, a current student, and the director of disability resources, as well as one of our academic lecturers who went to Columbia and is from a diverse background. And there tends to be a barbell experience with families. You either have families who are first generation, they don't know anything about law school, but they know you're doing something great. So they're going to try to support you in whatever way they can. You have other families who know you're in law school. They may not be happy about it. And as Cindy was saying, they don't understand why you can't continue to maintain your previous obligations to them. So I figured we'd have 3 to 10 people there, and we had about 50, and the parents had really great questions. And I'm hoping that that will lead to continued support for students and just really getting students to understand how to set boundaries with perhaps not offending their families and destroying those relationships. But as we all know, the law is a jealous mistress, and she is always beckoning. So I just try to impress that upon the families. But that is the program in a nutshell. There's a lot more to it. We also have faculty mentors, and I put on brunches every semester that are held at faculty's homes. And the students come out, and we do a potluck, and there's usually 75 people there. And the students, again, get to interact with faculty. And it's a real big boost for them. And they know that beyond the brunch, they can continue to interact with the faculty and come to them for guidance. So that's it in a nutshell. And if you have any questions.
That's a big nutshell.
It is.
It really is a huge program. But between the two of you, I had, when I was preparing for this, I was thinking, wouldn't it be great if a school had this or this or this? And literally, I was checking those off as I heard from both of you on all the things that you're doing. And those are wonderful programs. What I wanted to do, because we don't have that much time left, is to open it up to the audience, to the law schools who are represented out here, to talk about what they do, about any questions they may have for the panelists, anything like that. If you have any other ideas, it's, like I said, a lot of programs that have been discussed thus far, but if you have other programs that you have, other programs you're thinking of, or something you want to ask about on how to start a program that's been discussed up here, then let's hear from you. Out in the audience. You guys were overwhelming. You were so good.
Thank you.
There we go. Yes. Wait. You see Irvine? Yes.
Hello. Just a quick question. How do you guys work with the various affinity groups? How do you incorporate those activities with some of the things that you're doing? And by affinity groups?
Yeah, no.
Okay.
So I guess one of the things we learned with supporting the affinity groups, that it's more than just giving them a budget every year like any other group. I think you mentioned something about graduation. So one of the biggest things of the year is we support graduation. Any affinity group that wants, like La Raza has a huge one, Apalsa has a big one, Balsa has, and where we won't pay for it, our development department will help them raise money for these activities. The other thing we started to do more of was this year we went to each affinity group and said, each of you pick some big activity you're going to do this year, and let me get you the resources to make sure like this event is the event you always wanted to have, happen. Because we wanted them to know it's not just on you to promote, diversity and culture on campus. The administration is committed to this. So we asked them each pick one activity over the course of the year, and we will put all of our resources into making that, a bigger event for you, not just something you're scheduling between classes. And then we have put a lot of effort into alumni chapters of those affinity groups too. We just started the Armenian law students alumni chapter. Any one that wants to do it to get that involvement. The LGBTQ outlaw is working on an alumni chapter. So we're trying our best to help them build their programs beyond that we brought a speaker to campus.
And so at UC Hastings, through the Diversity, Equity, and Inclusion Working Group, we're a newer group, but one of the things we decided that we would do is that if students had, affinity groups had conferences or things of that nature that they wanted to travel to, or particular events that they thought were significant for their programming around diversity, that we would accommodate them financially. So we've been doing that. Also, one of my students is the newly elected president of the whole student body. And so he works with all of the affinity groups as well. So there'll be a closer relationship from my standpoint for me working with them, but we support their graduations. I'm the MC at the Balsa graduation this weekend. I'm also ordering the cake and getting chairs and God knows what else. And we provide a lot of advice and counsel to students. We help them source resources if they need, speakers for their diversity day. I go and attend diversity day. I speak. I help with recruitment. So we're just open to whatever it is that they want to do, and we're evolving in our approach to support students in an increased way.
I just wanted to make a comment that I graduated 41 years ago from Berkeley and from the law school. And one of the most important connections that I had there was what was then the Asian American Law Students Association, where we would have retreats and we met with alums. And that was a very big part of my being able to feel empowered that I could succeed when there were only 4 APA women in my class. And all of us have done very, very well. And I think and we're all still in contact. All of us from that group. I still one of my big mentors from ALSA was Dale Minami, who went on to do all sorts of very, very important things. But he was one of the people who made me feel like, yes, it's a normal thing for an APA to be a lawyer in California, even though there were just a handful of us.
So this may be a bit of an odd question. So you showed the slide that talked about how the unaccredited registered schools report having higher levels of diversity, but they also have higher levels of people not reporting. Yeah. We find ourselves in that situation. Of our students who report their ethnicity, about half report being diverse. However, close to 40% or whatever the number is don't report. So, if we wanted to try and increase our outreach to different groups, part of the problem is knowing who to reach out to. So I realize that the dynamic's different in an in-person school, but I was wondering if you or if anyone in the room had any thoughts on how do you get more students to self-identify so that you can know to offer these things?
Well, one thing I'll tell you is that we are adjusting the categories.
Can't hear.
How is that? Okay, so one thing I'll tell you is that we're adjusting the categories because one thing that we've discovered so far is people will not self-select their category when they do not see their category. So through CS Bars, you'll see some discussion of that, and I turn it over to the panel for any further comment.
I mean, just one short thing I'll add is you sometimes have to ask more than once. That was one of the things we realized. So we started, a lot of data comes initially from the application, but then we realized, okay, during orientation, we're going to ask again. And then maybe at another date when we're doing something else that's supporting us, we'll ask again. So like I said, this is the first year we formally supported First to Go. So this will be I'm third year class graduating. We were ordering stoles, sent out an email, oh, come pick up your stoles. And we had like 25 students who said, I never participated in a program for First to Go. And we're like, where have you been? So that's when we realized, like, okay, we're going to have to ask you in your application. We're going to have to ask you in orientation. We're going to have to, and then part of it was too, once you're offering them something, they come out of the woodwork. Just saying.
No, I agree. That's been my experience as well. And most typically, you will get that information from an application, but there are times when it actually isn't there. So in much the same way that Loyola asks on more than one occasion, we do the same thing. And it's true because their currency is in what you're offering them. So to the extent that something's offered that they identify with, you can often find out that way. But I think it's, a lot of tenacity in terms of pursuing that. And as you were mentioning, the categories are also changing too. So sometimes just knowing like where we're headed in terms of what we need to list for people to be able to self-identify, I think is helpful.
And I wonder sometimes about, again, when people are asked to reveal their race, this is something that comes up all the way through the practice and through the judiciary. People who say, oh, I don't want to say. And for the law schools, at least you have this other category of first to go to law school, which I think doesn't have, it has more of a gee, I am special type of connotation to it. You might be able to get that information even when people won't self-report their race.
If I can also add, it matters how you ask. And so one of the things that we're working on with CS bars is like what Debbie was talking about in terms of discipline. How you ask, I think, impacts the answers. And we're seeing that even with the non-conforming, non-binary gender, we had 6 subcategories to that. And so it really is, and we recognize in the past demographics for CS bars, other and declined to state were together, right? And so part of it could just be the survey design tool itself. So.
And just when you're talking about the survey style, we have used university institutional research a lot more for these type of things. Like I don't send out a survey anymore that I don't send to them and say, will you look at the way the question's being asked? Am I going to actually get what I want? Is there something about the way we're asking it that's going to limit the responses? So I don't go on my own sort of wisdom and knowledge. We try our best to send things back to institutional research.
So I wanted to, this is on. Okay, hopefully this will start working. I wanted to make the observation that the different student groups can have very different kinds of dynamics. So for example, at Southwestern and I think Loyola, the critical mass of Latino students has been present and very large for a long time. So that's a group where in my observations, they have had consistently strong leadership. They're enthusiastic about their programming. Much of it is traditional. With Asian American students, we have to keep reminding ourselves that the numbers remain relatively small in the profession, and they are very very capable group and have their own ideas. And then with respect to African Americans, our numbers are smaller. There's not that same feeling of critical mass, even though the school has an incredible history. So as a dean, you want to be thinking differently about each group and making sure that you have key staff who are doing a lot of listening and interacting to make sure that we're sending the messages that we want to support these groups and we want to know which programs are most important to them. I think this has been inherent in what both of you have been saying, but it can be in a situation where there is a lot of racial diversity in the aggregate, that a lot of faculty members think, well, this is all just fine and everything is going along by itself. And in my experience, that's really not the case. And you need to keep making sure that you're bending over backwards to be supportive, because in the rest of the culture, people are continuing to experience such racism at this point in time.
So I was just going to say, that's why we're about to do another climate survey, because every school is a little bit different, you know, into your populations of what's the larger group, or is it a faculty issue, and we can make assumptions. And then the climate survey gives you the data to go back to faculty and say, you think you're doing a great job, but you know, I found in surveying students, the number one thing when we did our task force or workshop on equity, the number one thing students said is, can you train your faculty? Mm-hmm. And I was blown away, because we've always had a reputation for having really popular faculty. They're like, no, they're lovely people, but I don't like somebody in class asking me in front of 30 other people what honorific I would like, you know. So people were trying to say, would you like to be Mr., Ms., or Mix, right? And they said, I don't want somebody asking me that out in front of 50 people on my first day of law school. And then again, the faculty had the right intention. So, you know, there's something, the survey will give you the data to go back to faculty and say, you're doing the right thing. You know, you have the best of intentions, but you're making it challenging for this group of people. So that's why I think climate surveys are really important.
They are valuable. It's interesting that you said what you said at our very first diversity, equity, and inclusion meeting. The first thing I said is, we need to have a cultural competency and sensitivity training for the faculty. And it's often easier said than done. And it's necessary for a variety of reasons, I think, beyond even the things that we think are obvious. I mean, even in terms of some of the generational gaps that we have now in the learning styles of students, you know, versus professors who've been there for 30 or 40 years, they're having to employ new skills and ways to interact with millennials that they haven't had to do in the past. And that presents their own challenges. And then, you know, oftentimes things come up in criminal law classes or constitutional law classes that make students very uncomfortable. And I've had my own personal experiences just as a faculty member of people making remarks that were really quite off the mark, that really were true microaggressions. Did you grow up in the projects on Sutter? No, my mother had a master's degree and was a dean at her college. So no, I did not. So I'm not sure why you would make that assumption. You know, and things like that just happen. And those are the kinds of things that, quite frankly, cannot be continued to be overlooked. And people have to understand that really impacts the culture. And if students don't feel included, or if they feel that they're in a de facto hostile environment because of those kinds of things, then you're just going to have a wash, rinse, and repeat experience at your school. And there are lots of firms and everything have been doing diversity efforts for years, but the numbers haven't really changed. So I think people have to really start being more assertive and thinking more outside the box about what they're doing around these diversity conversations.
I thought that was really interesting when you mentioned that. I thought about, I would get asked, gee, was your family in the internment camps during World War II? Now, for me and for Japanese Americans, it's like, of course they were. What do you mean, were they in the internment camps? They were in the internment camps. But one thing that actually Dean Prager's question raised for me, because I know that Southwestern works very hard, as does Loyola here in Los Angeles, to work with diverse bar groups and the specialty bar groups. And one of the things that any school can do is to reach out to the local bar groups, especially if you have affinity bar groups, women's bar groups, those things. They would love to collaborate with your law school. They would love to, especially to use, you know, your space to have meetings and to invite students in, to recruit students to become members. You know, this is where most student memberships for bar associations are free. And so it's a great way for bar associations to get new members in the door who will stay connected after they graduate. But those connections also can get your students jobs and externships and internships and clerkships. So I think that's a wonderful way of every school to be able to reach out. And honestly, all you need to do is to go on the website for the various bar groups, and they're fairly easy to find. If anybody has any questions, I think I know every single bar group in the entire state, so reach out to me. But to find it, you contact the president, you contact somebody who's an alum perhaps, but it doesn't have to be an alum. And just say, you know, we'd love to have, say, a bar group fair at our school where people can where you can have all your students in to meet up with all the various organizations that are available. And that, you know, again, it's going to help them on a lifelong basis. It's not just something that's for now.
If I can just also pivot the conversation. The State Bar is asking how we can be helpful for you to support diverse students. We can gather this information about what makes really key aspects of strong programming. Do you want us to basically, you know, provide more linkages to affinity bars? Like, this is about wanting to support you so that we can support our profession and support these students. And so do you have anything that comes to mind in terms of what we could do to be supportive to enhance these efforts?
I think one thing I'd like to do is to circulate the contact information for all those affinity bars throughout the state. So that's not just because it's a little hard to find, frankly, on the bar's website. And so if we can just to everybody who gets this or all the law schools in the state to circulate that information and encourage you to reach out to those bars, like I said, you're going to get a great response. You really are, especially if you're offering free space.
Well, yeah, and to that point, we LEOP every year I help the Minority Bar Coalition put on their annual award ceremony. This year, I think it was on my birthday, but I made sure they had the space, and it's a remarkable showing of all these minority bars, and they're giving out awards, and so the students are also invited to come, and it's a really kind of nice and efficient way to get everybody together. And there's this mutual agreement and expectation now that we'll continue to do that for them. And so that's been a nice partnership as well.
And a lot of the larger areas have sort of multicultural bar alliances. We have in Los Angeles the MCBA. And if you contact them and you ask them to circulate information to all of their members, then you'll be able to circulate in Los Angeles. We're talking, I think we have, the MCBA has, I think, 33 member bars, and we cover everything. Just the total gamut of affinity bars. So you can reach everybody with a fairly small amount of effort.
And those that have scholarship opportunities, if we could get like a listing, like one list without having to search everywhere, because there are always students every year who, you know, their first year is covered, but they haven't made plans somehow for the next 2 years, and they come looking for scholarships. And we know there's those available for diversity bars, but if there was one place.
You know, that's actually a wonderful idea. I was just actually, tonight is the Filipino American Bar Association installation dinner. And I was noticing they're giving out just a huge number of scholarships just by themselves. So that's a really good idea on things that we could do to gather information.
And in addition to the scholarships, there are also summer stipends and summer internships as well.
So I want to thank you, Cindy. That was a really great suggestion. Pivoting back to what Helen was saying, you know, the State Bar has been looking at the diversity pipeline. And one of the areas is the data that Helen had walked through earlier. One of the areas where the pipeline seems a little bit leaky from the data that we currently have is in law schools. So from matriculation to graduation, for the information that we currently have from the ABA schools, we see the disparity gap growing. And because of the relationship that the State Bar has with all of you, we felt like that we were uniquely situated to address this part of the pipeline. And so one of the objectives, and I think Helen had talked about it earlier, one of our objectives is to examine what programs are out there. So we've surveyed all of you. We're going to be looking nationally to see if we can get some information on what programs people have that are effective. And our goal is to support you in providing additional programming, sharing best practices, finding out the types of things that would be beneficial, like identifying all of the the affinity bar associations with scholarships and putting that in a single place, figuring out what are the things that the State Bar can do to assist you as you work with your students to shore up that pipeline in law school.
I mean, I think one thing that I would say is just from hearing the programs at Loyola and UC Hastings is that I think it would be very helpful to have available to all the law schools in California more information about the gamut of programs that are already being done, so that if you're, and also hopefully to be able to go back to you two and ask for advice if there's something that you want to replicate in your own law school, that if we had that as an available resource, that would be tremendous.
One question I wonder is when you were talking about supporting affinity associations, how many schools give space to the affinity associations on their campus, where they have their own,
Like Law Students Association, that type of thing.
Because that's one thing our students have asked for is, we're walking around campus and many of them are used to, in undergrad, having that place on campus where, particularly when you're only, 25 of X number of students or whatever, they would like a place where they can go and that is theirs. And I'm wondering if other schools are providing that. I know real estate on law school campuses is hard to get to, but I'm curious if anybody's doing that.
I remember Berkeley had that when I was there. We had our own little space. It was a carrel. It was a small space, but we didn't have that many people, so we fit in there.
Yeah, we have a intercultural room that any people can use for events, or those groups can reserve it, but it's not like an individual space. Just curious. Because that's something students have asked for. I need a safe space.
Does anybody have that? A dedicated space for the groups? For each group? No?
All right. Yes. So I want to thank the panel. I want to thank the judge. Really, this isn't just the only time to have this conversation. We really wanted to make this an opportunity to start the discussion. And should you have other ideas or to say, actually, this other person at my school would have better answers, a better thought on this, I would really encourage you to have them reach out to me. My email is listed below because we really want to get your feedback because we want to help support you to support your students to graduation because we know that you've already invested in them and you too want them to succeed. And so what we're really hoping is to get your feedback and learning to help drive the priority for the State Bar to invest. And with that, I just want to thank Cindy, Elizabeth, and Judge Holly. If we can give them a hand.
Thank you.
Stretch, feel free to stand and do that so you can be present and be participatory for the next session, which is also out of the Office of Access and Inclusion, focusing on the Justice Gap study, which is a new initiative here at the bar, and it involves a component that is specifically for law schools and law students. We will be having focus groups and surveys of law students in terms of how they choose their career and what the barriers are to supporting a career in public interest. And Helen Hong and Donna Hershkowitz will be chairing this discussion.
So when we talk about the justice gap, many of you know that the need, just outstrips the capacity in the community. And we're talking about especially low and moderate income Californians being able to afford legal services. Historically, the State Bar of California has primarily addressed this through the funding of IOLTA grants to 100 legal aid organizations throughout the state in all 58 counties. But what we really wanted to focus on is really measuring what that justice gap looks like throughout the state, addressing how that looks like in the geography in rural versus urban based on population for senior citizens, the elderly, veterans. And so what we've done is we are modeling the Justice Gap Study after the Legal Services Corporation that issued a report in 2018 to Congress that showed that 87% of U.S. residents have unmet legal needs. And so we are doing a research study with them that includes a panel survey as well as interviews talking to Californians about what their legal needs are in a variety of matters. And so this study is going to be part of 4 different areas that include, 1, talking to just Californians, both low income and moderate income. 2, looking at how recruitment and retention into, sorry, let me take a step back. 1 is doing an intake study on the people that go to legal aid organizations who already have identified a legal aid issue and saying whether or not they can be helped or not be helped because of capacity. And then 3rd, looking at the recruitment and retention issue for legal aid programs. I'm a former legal aid lawyer. And back in the day, and still true today, if you wanted to be a legal aid lawyer, you just knew that you were going to be poor for the rest of your life. And so one of the things that the State Bar is looking at is, does law school debt impact the justice gap because fewer people can afford to go into legal aid work? So what we're doing is looking at whether or not the State Bar would look at ways to address the justice gap by supporting a loan repayment program. So we're looking at that data that will also include what are the barriers to entry and retention to legal aid. I can tell you anecdotally from major legal aid programs throughout the state that they have a lot more jobs and they're seeing fewer applicants from law school. They're saying that they're not getting the applications, and many of you know, particularly here in Los Angeles, with the homelessness dollars and the state dollars, there are a lot more positions that they're just unable to fill. In rural areas, they're seeing a different type of barrier in terms of recruiting them into rural areas and having them stay in rural areas. But what we're seeing is just an overall larger gap. And so part of the study will be addressing that. And I'm going to the other part of it is actually talking to law school students. And so I'm going to pass it on to Donna.
Can you hear me? How about now? There we go. It's odd talking to you from this angle. I'm used to standing on the side of the room. So as Helen said, our Justice Gap study is modeled after the study that was done nationally in 2017. What is unique about the California study is this additional focus on the cost of law school and the impact that it has on access to justice. So the State Bar is going to be partnering with the Legal Aid Association of California to try and figure this issue out a little bit. The Legal Aid Association of California is putting together a survey. We'd like to survey law students, 1st year, 2nd year, 3rd year, 7th year. We'd like to survey law students really at all different entry points in law school, find out, we may have a lot more people who are 1st year in law school who feel like they are interested in going into a legal services profession. And then as the debt accrues, as they get closer to graduation, feel that that is no longer an option. And we want to sort of trace that trajectory and see when and if that is happening, how that's happening, why that's happening, what are the biggest barriers for students. We are also interested in doing some focus groups to follow up on those surveys.
And because we are talking about talking to your students, we wanted to talk to you and find out a couple of things. Your thoughts on how to approach doing a survey that would get the highest level of participation. When we asked folks in San Francisco yesterday about the timing for doing a survey, they all said March. But being that we can't turn back the clock and the goal is to have this study completed by the end of the calendar year, there was a consensus in the room in San Francisco that September would probably be the optimal time to launch the study. We'd like your input on that as well. And also, ultimately, we're going to be asking for your assistance in distributing the study to your students. But we'd also like your thoughts on other ways to interact with your students that might be better opportunities to get us this information. We are likely also going to be looking at potentially through the California Young Lawyers Association, tracking this trajectory a little bit further and finding out if folks did or did not ultimately, within the first few years out of law school, go into legal services, what the reason for that was, and sort of how that tracks back to whether they were interested in doing it first year, second year, at some point through law school, and ultimately did not, or switched direction at some point, getting that feedback from them as well. So we'd really be interested in hearing from you all specifically on this part of the Justice Gap study, where we're looking at the impact of law school debt and how that may or may not impact entry into legal services organizations as a career, and ultimately then affecting the Justice Gap. So I'm going to pose a direct question to you then. So let's first talk about the best approaches to get information from your students. As I said, we're looking at doing a survey that we would potentially email out to all of your students, and then following up with some focus groups in a couple of areas, in a few schools around the state. So if you can let me know if that might be an effective, or particularly let me know if that might be a particularly ineffective method for getting feedback from law students.
I can't imagine I'm going to need this, but I would just want to suggest that while email surveys are something that folks are used to, students are inundated with email, they don't read it. So there's got to be some other follow-ups or some incentives or just outright bribes.
Yeah. We're looking at both incentives and the outright bribes, yes.
Do you have the ability to send a survey via text? Do we have like their phone numbers on file? Can we do that? Because that might be more effective.
I would imagine that the technology would certainly exist, that at the very least we could send a link we would send a link to a survey that we could text to folks, yeah. We should be able to develop that, I would think.
Well, I think that's a good idea. Just one bit of caution is I know that some students can be really, really, for lack of a better term, paranoid about their private information. And I know that there's certain information they have to submit to the State Bar anyway, but I do think that that's actually a great idea, but also it could make people angry as well. But I mean, there's no satisfying everyone.
And certainly we don't have everybody's contact information, and that's why we would be asking all of you to be distributing the link, whether by text, by email. If you know, we can obviously develop the language of the email or the text, so that could be, you know, go out consistently. If you wanted us to do that, but certainly maybe getting an email from or a text from your school, they would be more likely maybe to respond.
Yeah, so there will be a multifaceted effort in order to engage students, not only through hopefully all the law schools within California, but through employers and affinity groups. And so we're trying to hit them in different ways. As a follow-up to Susan's comment, we are also interested in hosting through the Legal Aid Association of California, about 8 to 12 in-person focus groups with law students that reflect both ABA and CS bar types of law schools. And so if you are interested in hosting one at your campus, our staff, the Legal Aid Association staff, would be going out. We would be providing the food, blah, blah, blah. And so if you are interested, please hit me up on my email in terms of your interest in hosting such a group to get feedback.
This may be a little bit of a controversial interjection, but I've been the dean at 5 different law schools over a long period of time. And it seems to me that the situation at different law schools demands different responses. If you're at an upper tier law school, the question about how you induce someone to come into pro bono work has to be a very different exercise than if you're in one of the lower tier schools where, from my own experience, many of those students would grab at the chance to be able to work in pro bono work or anything else, but generally don't have the opportunity because the hiring personnel are looking for higher tier quality institutions in order to place those students. So I think you have to look at some of the realities about the differentiation within law schools. In terms of how you reach out to students, I think that becomes, as I think a number of people have said, quite difficult because it's hard to get our students to respond very often to very basic things that need to be done within the law school in order to further their careers, to get information about the bar and a variety of other things. I'm not sure I know the solution for how best to get the kind of survey information that you're looking for. It may be that linking it to some of the other studies that are ongoing about paths to law school would be a way of doing that, and the Association of American Law Schools has been very actively involved in doing surveys about what's drawing people into the profession, which can often be a tremendous source of information about the motivation that individuals may have in deciding to go to law school.
So I'm curious if any of you in the room have offer loan repayment programs or stipends to students to be able to do this kind of work.
So hopefully you or your school had responded to the survey we sent out through admissions. If not, there is a blue sheet of paper. If you could fill that out, what we're hoping to do is to also compile that information.
Yes, we do have, and we did respond to the survey, but we offer loan repayment programs.
Well, we're at Pepperdine Law, and we offer a loan repayment assistance program to any students that have been working in the public service sector for a year. And they just have to, so we have some eligibility rules, like making gross adjusted income of $70,000 or joint income of $100,000 for the household. And every year the students can reapply as long as they still meet our eligibility criteria.
We also at Loyola have a loan assistance program. What I was going to tee up though, we were doing research. As I said, again, we had a task force put together, kind of review this to see if there was any way to provide assistance to more people. And one of the things we found that there are some schools going to, because clearly there's a ton of formulas on how you could do this, but we decided not to do it. But there are some schools that are going to we will pay you what you pay. So we pay a percentage based on like your income and your payment and that sort of thing, to help you along. But meaning what you pay, because a lot of the programs now to allow you to pay interest only, right? Some schools are going to try to cover more students, will make that interest payment for you, And so you find people who are in loan for much longer time periods. It's not actually, really addressing paying down their principal. So there's a lot of variety out there in what loan assistance looks like, and what people are getting. And then we do have our own separate post-grad fellowships that Loyola gives also.
So I just want to kind of widen up the conversation a little bit. One is that, yes, we're looking at traditional historical ways of thinking about access to justice as an legal aid lawyer. And so one of the aspects that we're looking at is not only a loan repayment program, but also a literature review to see what's really affecting student behavior. There has been some data saying that actually, if you have the same amount of dollars, what really changes the behavior of students is the upfront scholarship, not the loan repayment at the end. Even if it's the same dollar amount, it's a psychological debt load that impacts career choice. Along with that, in terms of the comment regarding like the level of law school, we're not only looking at legal aid, but we're also looking at incubators. We see that, again, we're not only talking about those that can qualify for free legal services, which is 125% of poverty, which is a person of one making less than $16,000. We know for the vast majority of the working poor in Los Angeles don't qualify for legal aid, but they also cannot afford a regular lawyer, regular meaning big law or mid law. And so when we're talking about different kinds of suggestions for shrinking the access to justice gap, does that mean the different types of lawyer referral services for modest means? Does that mean helping incubate solo practitioners that will practice or that will do a sliding scale, looking at limited scope practice? And so part of this conversation is not just through one area. How do we as a sector look at promoting more employment for law students and then also services and resources for Californians?
I just wanted to add, before getting to that at Pepperdine, we also do support with summer funding. And so formally through our financial aid office, also a student organization, our public interest law student organization does a fundraiser every year, and then they provide stipends you can apply for, I think in conjunction with financial aid, to get, and our legal aid clinics as well. If they are working with the legal aid clinics in the summer, they can get some support for that. So for their summer student provisions, and so hopefully to help encourage that type of low bono or pro bono work before they even graduate. And then in our career development office, we also do a little bit of a crowdsourcing of some different funding opportunities that are available that we share with our students. So when they come in and they talk about wanting to do, whatever type of work, but oh my goodness, how am I ever going to pay back my debts? Or we do source some of those. We send them out to financial aid, but we tell them from the career counselor perspective, here are ways you can accomplish your career and professional goals while still feeling like you can survive and eat, because that's important too, right? So
I just had a question. I'm hearing about some of the loan repayment and the help, but I'm hearing it from all private schools. It sounds like it's all private schools. Are any of the public schools able to do any of that kind of help with with the financing for the students?
I'm the dean of Pacific Coast University School of Law, and we are we're a CALS accredited school, so we don't get WASC accredited or WASC financing because we can't afford to go to WASC. So what our students do is that they pay off their debt each year because they're so affordable, so that when our students graduate, they don't owe anything and they can actually go into work for legal aid or the public defender's office and survive. So.
Yeah, I was gonna. Oh, sorry. So I was gonna echo that. So we're a unaccredited registered school. Our tuition is $12,000, so we don't have loan repayment, but people graduate with a lot less debt. I want to address the point. I want to emphasize how important I think this is to think about these different models, right? Because to your point, Helen, about incubators. So when I was at Whittier and we helped them launch their incubator program in participation with Legal Aid Society of Orange County, So we would survey first-year students. About 40% wanted to be criminal lawyers, 30% wanted to do human rights, 20% wanted to do entertainment, 10% wanted to do everything else, right? And by the end, of course, very few people are doing those things. And then by the end, when they're looking at the incubator program, I had students, graduates who said, it sounds great. I've got $200,000 in loans. I can't afford to hang out a shingle and represent the little guy. So I do think that that's a really important issue. We need to think about it in different ways because legal aid doesn't have the funding to hire everybody who wants those jobs anyway. I think we also should keep in mind the idea about using technology, right? Because especially in a large geographic state like California, there's so many areas that are underrepresented. And if we can promote ways to link up people in different areas or promote people serving those populations as well, that's a really important piece of the access to justice gap as well.
We do have a working group on use of technology, and so that's something that we are looking at very carefully. One of the aspects that I'd like to just ask the group before we close is, particularly for the CALs and the CS bars, is there a gap between recruitment from legal aid organizations specifically to your schools? One of the comments that I've received is that there's a lack of pipeline for students who are interested in legal aid, but it's also because there's a lack of funding. The ones that want to do it can't afford an unpaid summer. And so whether or not some of the comments that I've heard is whether or not there's not enough focused recruitment on CALs as well.
I'm Marie Carmona from Pacific Coast University. One of the things for students at the CALs is the legal aid requirement for hourly commitment per week is more than the commitment they can meet. If it could maybe be stretched over the entirety of their school career, it might be more reasonable, but it's very difficult for a full-time working person who's full-time law students to give up 20 extra hours a week. That's just a suggestion.
Thank you. Well, if you have other thoughts or questions, my email is listed below. I would welcome those, any input, and I look forward to working with you throughout the years. Thank you.
So we're in the home stretch now. Thank you for staying with us. We're going to be talking about a few state bar updates, and I'm going to invite up Tammy Campbell, who is our program manager for operations and management here at the State Bar, which includes a number of things, including the actual logistics to put on the first-year law students exam, the legal specialization exam, and the bar exam. And I'll be joining her to talk a little bit about our new AIMS computer system as well.
Good afternoon, everyone. So over the past several years, administering the California bar exam has presented various challenges that have included facility availability, with the primary challenges involving proctor recruitment. The issues with recruitment have revolved around hiring a sufficient number of proctors that can be proficient at the job, as well as training these new recruits. Historically, the California State Bar has maintained a steady proctor pool to draw from for each exam administration. Over the years, that proctor pool has reduced in size due to a variety of reasons, including the fact that many proctors have been working with the State Bar for a long time and are aging out, as well as a reduction in the number of people looking for seasonal work assignments. When proctors are not available, the State Bar uses personnel from temp agencies, which increases costs, is resource intensive, and less efficient for the administration of the bar exam. Given the challenges in providing sufficient quality proctors to ensure an effective administration of the examination, multiple options are being explored to find a solution that might improve the quality of the bar exam administration, and one of those options is the feasibility of reducing test centers. Based on availability of facilities, test center locations can vary from one exam administration to another. For the July California bar exam, we typically contract with at least 13 facilities across the state that includes both standard and testing accommodation test centers. Some of the regions have experienced facility availability issues and proctor shortages more than other areas. In Northern California, one site that has been identified is the Santa Clara Convention Center, a location consistently challenged with identifying a sufficient number of proctors. In Southern California, the standard exam sites located in the downtown Los Angeles vicinity has experienced challenges with identifying a sufficient number of proctors, as well as difficulty with contracting space based on the nature of our event. Also in the San Diego area, the standard exam site has experienced difficulties in securing facilities based on the availability and the cost of conference space in the area and the possibility of the space normally being used closing. Another option that is being explored as a method that might contribute to the improvement and quality of the bar exam administration is online proctoring. Online proctoring increases the quality of proctoring as it uses both a behind-the-scenes proctor staffed by an online proctor company and artificial intelligence to detect cheating or erratic behavior. Online proctoring accommodates a ratio of 4 applicants per online proctor by combining a live proctor with artificial intelligence through the use of a gooseneck camera or the camera on the applicant's computer. To prevent access to external information on the applicant's computer, the program is designed to block access to anything other than the ExamSoft testing program and the online proctor program. Artificial intelligence monitors eye and body movement and reports back to the live human proctor. This would then allow the online proctor to communicate directly with the applicant or with the on-site Office of Admissions staff. Although there would still be proctors on site at the test center, it would require far fewer proctors than currently required. The on-site proctors will continue to provide security, facilitate the distribution and collection of exam materials, and monitor applicants during testing while troubleshooting any issues that may arise with the guidance of the on-site admission staff. Both options have been brought forth to the Committee of Bar Examiners and were conceptually approved. In June, online proctoring will be tested during the upcoming administration of the June first-year law students examination, with staff planning to pilot online proctoring at the South San Francisco Conference Center with approximately 125 applicants, and at the Doubletree Westside Culver City with approximately 20 testing accommodation applicants. This will provide an opportunity to see how it works and to better prepare for implementation for online proctoring during the administration of the July 19 California bar examination. The test centers have been identified for the July exam are the Ontario Convention Center with approximately 456 applicants and the Hilton Sacramento Arden West with approximately 60 to 80 testing accommodation applicants. And that's all I have. And at this time, I'd like to open up to see if anybody has any questions or comments with regards to those two items.
Just a quick question for students. If you do implement it in July 2019, will students signing up for Ontario or Sacramento be notified that it's going to be a facility that uses new tech?
Yes, we do plan on notifying the students to let them know that their test center will involve that.
And only those two?
Only those two sites, yes.
Could you explain a little bit more about what exactly the AI proctoring is? Because you said it's going to monitor eye movement, et cetera, and be somehow compartmentalized within their computer, which means, I imagine, that it's something that they have to download or it's a part of that, that program or programming. And so have those 400 and some students at the Ontario Center, have they opted in? Have they consent? Like, how exactly is this working?
So with the artificial intelligence, it does monitor the eye and the hand movements, and it notifies the proctor on the other end that there is some aspect of a possible violation of something that they're not doing. We are definitely going to let these students know at this point. We have not notified applicants, but we will be notifying the applicants of what our intentions are.
But I'm sorry, can you clarify? Is that a part of ExamSoft so that they're what's it called? That they're thank you, the camera. So that their camera is the one that's doing it? Like, how is it another camera that's set up 10 feet away from them?
Well, there are two different options. There is one which is a gooseneck camera, similar to this microphone, but the option that we're looking at is where it will be the camera on their laptop. So as they're accessing the ExamSoft program, Exemplify, to take their test, they will have the camera on their computer monitoring their movement through the online proctoring program that will be on their computer as well.
I'm so sorry if I'm taking up anybody else's time or question.
No. Oops, sorry. No. So currently, the remote proctoring is only allowable for those people who are taking a laptop exam. Everyone that registers for the bar exam or the baby bar or the first year law students exam that use ExamSoft have to install that software. For the proctoring system, it's an login authentication process. So that there's not an additional software that's required. It's more of a login at the exam site. And we would have on-site technicians that'll help the students log on to that system. So ExamSoft plus the vendor that we're using for this are compatible. So again, the students that would be qualifying for this level of monitoring or this type of monitoring are those that are using the ExamSoft, which is about 90% of our exam applicants.
I apologize. I have one more question. You said that you're going to notify the students, but do they get to opt in, or are you just randomly selecting those students and they're required to?
We're using those two sites. So the idea is we send information out. We have a bulletin that we send out on information related to the bar exam. So we would alert students in that way. So students that are not at those two test sites are going to get the regular in-person proctoring, and those that are scheduled to be at those two sites will have online proctoring.
So there's no opt-out? Well, we're from the University of Laverne, so 95% of our students are going to Ontario because it's down the street from us. So they don't have a choice of whether or not to opt in for this very first time.
That's probably something we'll confer with our general counsel, but I think the idea, we'll still need on-site proctors in the event that, for example, a camera doesn't work or there's some technical difficulty around that. But in terms of an opt-in, I think it's something that we probably need to discuss with our general counsel.
Thank you.
Mm-hmm.
Do any other jurisdictions use this?
No, we're going to be the first bar jurisdiction that uses online or remote proctoring. However, there are a lot of law schools and other schools that use it. So online schools have used remote proctoring in the past and have made recommendations to us about the process. And yes, licensing agencies. So for example, one of the vendors that we've been exploring conducts this on a regular basis for both real estate license and I think medical examiner's license. So there are other licensing institutions that use remote proctoring.
I'm not sure whether this is the right place to ask this question. It's the only place I've seen the word online all day. given that the MPRE goes online fully in March of 2020, and that that the national conference does have online practice MBEs, the issue of the MBE is per state, not by the NCBE. They can't do that. Given this technology, is the state bar at all considering making the MBE online as part of the bar exam at some point?
So the decision to put the MBE online is one that has to be determined by the National Conference of Bar Examiners. We have talked to them about our remote proctoring, and they're eager to learn about our experiences with remote proctoring. In the event that they ever get online, they would be probably interested, based on our experience, in remote proctoring as well.
No more questions? Okay, thank you.
Okay, so we're moving on to our final topic. For the most part, we've invited you here so we can get a window on what your students see. But in this part of the presentation, we will give you a window into what your students see when they use our new admissions information management system. We launched this system in March, and it is now the way that students register for all of the things that they might do with the state bar. It's a Salesforce backbone system. We use a special government cloud for extra security to make sure that their information is protected. And we just want to make sure that you know that we have migrated all of the student services over to AIMS. And those student services haven't changed, the timelines haven't changed, the fees haven't changed, just the method. We keep the paper processes as a backup, but now at this point, using the online system will in every case be the fastest way for the students to communicate. So it underscores some things that you've already known and that I'm sure that you've said to the students many, many times. Their first interaction with AIMS will be when they register as law students. And we know that they all register within the first 90 days, yes? This is more important than ever because we will always continue to communicate with students in a number of ways. People may decide to come to California later in their law school career if they're going to school in another state, but it's a very convenient way for us to be able to reach out to them and communicate because one thing we know about students is that they move. They change their cell phone number. They change their email address, and if they're able to keep that updated with us online in a way that they're used to doing, and yes, they can even do it on their phone in many cases, then that will really help us to communicate with them. And as we branch out and pursue some of the types of initiatives that we're doing today, that's another reason that having that type of contact information will really matter. I also received a special plea from the Department of Testing Accommodations to first of all thank your students for listening so well over the years and providing original paper certifications from their treating professionals. But in the future, please do have them know that instead they should take those certifications and upload them, whether they receive them from their provider electronically or in a paper form. We've found that that's the one area in particular where students are more likely to want to still use the paper process, but we can't encourage you enough. We're really ready to take it electronically. We thank you for your patience, and please do that. The other place is in the area of the practical training of law students. I think that some schools are used to sending applications in bulk, or we find that the student hasn't registered, which is the first step, and it delays their PTLS application when they'd like that very quickly because they'd like to get started in their clinic. So those are some of the things that we're noticing so far. We've generally been having good feedback. We have been working on the instructions in our system. We will be working soon on the instructions that we've updated on our website. They're accessible now, but as we get feedback from the students and also from you if need be, we'll continue to update those as well. So thank you for taking this step with us into the future. We're glad to get started, and we're glad for the capabilities that it will bring going forward. Are there any questions about our AIMS computer system or any comments from your students?
For the moral character application in general, is it exclusively online now? They no longer print and mail in a hard copy?
It is. Well, we keep paper backups of all of the things that we do, so students could choose that, but we would greatly prefer that they fully complete the application online. And they take their fingerprints after opening the application, so they'll get the proper form. And so that goes back to the earlier moral character presentation.
So the instructions have been changed. They no longer say to print out Form 2 for like criminal convictions and mail all that stuff in?
I'm looking to Mark to double check, and he's nodding his head yes.
100% electronic is a fair way to explain it now?
Mm-hmm. So for the purposes of the tape, we're confirming that that's correct. The application is now 100% online.
I had a student, a graduate of 2018, doing his Form F, and he phoned into the office and they told him to send a paper copy. I want to know in the future, so he had me fill it out in handwriting yesterday.
Mm-hmm.
When will the prompts be coming directly from you electronically to the school representative?
The Form F is the form that relates to law students for the purposes of the law school, what the student received at the law school. Amy, do you have further detail on that?
One of the issues you just described, so this is a 2018 student. We just transitioned into the AIMS system in February of this year. So we do have a few transition students, so that you might have some students who are still submitting hard copy files. If you remember, the process for moral character is you have 90 days from the point you start the application. So if you started in those 90 days in paper, we're granting the permission for those to finish by paper. So that could have been the circumstance with that student. But for the most part, when somebody's starting from scratch, we're encouraging them to use the online system.
Form F is the request for accommodations.
Mm-hmm. Oh, Form F.
Yes.
So this was a 2018 application or an application for this year?
2018 graduate applying for the July 2019 bar.
Do you know when they started their application? Because that would have had an effect.
No, I do not. I just wanted to know when I can anticipate getting the request purely electronically.
Okay, so as those paper files complete, those that started in paper will complete in paper, and so it just depends on the speed at which the student completes that application, but those that started march forward will be completely electronic.
So there's three areas for students where there's a paper that are paper application intensive. That includes testing accommodations and moral character. So again, that could have been a scenario where that student started their application in paper, but probably for the next rounds, it'll be electronic with the option for a paper if needed.
For the practical training forms, is that now automated? I mean, going to be online?
It is available through AIMS, yes.
So one of the things that I've been observing this year more than before is many of us have our dean of students be responsible for making sure that the information we're providing you is correct because they are closely aligned with the records function.
Mm-hmm.
But what I'm finding is the approvals are coming back to me as dean. If we want to change that, how do we do that with you all?
That's a question I'll have to take back. This is round one of our system. Certain things are going to an official law school email and certain things are more flexible. So I would have to research that and get back to you on this.
Oh, I just had a follow-up question. So the PTLS application has 3 components, one for the dean, one for the supervising and attorney, and for the student. And so your question is, for the dean, the receipt of confirmation that the student is enrolled is going back to the dean, or questions about that form are going back to the dean?
The only ones I've seen are ones where the bar has approved the certification.
Oh, yes. That is a receipt for the school to have that the student has been enrolled.
Right. And what I'm asking is, since, the dean's office is, the dean's office is located somewhere other than where the records function is, for most of us, the dean of students actually acts on behalf of the dean in supplying the information to you all. So I'm wondering if there's a way where the bar's communication back could also go to the same place that originates it, the dean of students.
We could probably touch base if we follow up. If you follow up with me, we could find a way so we can send it to the appropriate dean. But I think you're also highlighting something that we probably haven't discussed in terms of AIMS, and that is it's really designed at the moment as a law student portal. There have been intentions for us to create a law school portal where some of this information would be easier to to create more communication flow, whether it's formal documents requested from the schools, or such as transcripts, or these applications themselves, and that's something that we're still working on too.
Thank you.
So similarly, I'll anticipate the next question and confirm that pass lists for the February bar exam will be sent via U.S. mail to the schools. Are there any other questions about AIMS? Well, thank you to your students for their patience and for trying something new with us. With that said, that concludes our agenda for today. Thank you for participating with us in this new style of law school assembly, a day in conversation with the State Bar. We hope that you were able to share what was on your mind with us, learn a little bit more about what we are doing, and that you will talk to us when we send you a follow-up and we send you a follow-up evaluation. And as this continues, we'll also include my information on this. So at the end of the day, if you say, I want to get this to the person, but I'm not quite sure who that was, I'll be happy to forward things inside. We're interested to hear your comments about what we talked about today, what you'd like to hear about in the future, and your willingness to participate in any of the types of initiatives that we discussed today. Okay, and with that, I'll turn it to Amy for closing remarks as our office director.
Oh, yeah. I just want to thank everybody for joining us today. And I think we mentioned this when we first started, but if there are other topics that you're interested in for future law school assemblies, please let us know. We'd be happy to take those suggestions. Thank you.
Thank you.